moving slowly, so we already in too deep. Can't get no sleep on each other, heavy teasing all day, and when the sun sets, you asking me to come through, kick it with you. Night turn to morning dew, then you feel it rushing in, lose control. You don't wanna go slow, for sure. We both already know your place is my place now. My place is your place, let's face it. Baby, you know all the places. Places. My place is your place. My place. Your place is my place. Just face it. No one knows my places like you do. Your places like I do. My place like you do. Baby, don't stop. Got the key to the lock. We in our own zone. Make yourself at home. Get to know mine on the inside. Can meet at yours next time. And you feel it rushing in. Lose control. You don't wanna go slow, for sure. We both already know your place is my place now. My place is your place, let's face it. Baby, you know all the places.
Mic check, mic check. Hey, family. Hey, mic check, mic check. Hey, everybody. I see everybody out there. How's everybody doing? Hey, Copper, Aborigines, Lady Moon, TWA 17, Connecticut in the building. Hey, now. All right, now. And I'm sporting my hat because I was born here. How's everybody doing? I appreciate everybody waking up this morning. This is going to be an explosive segment this morning. I first want to thank my co-host. I love her to death. American Business is in the house and will be assisting me because I need help with this, reading this, and she's just so tired and she just wants to do it with me, and I appreciate it. She's always so helpful. She has the most delicate voice and the greatest personality, and she's so loving. I love her so much. I do. Americanism, say hi to everybody.
Peace, Sister Bethy. Good morning.
Look at her. Peace, Sister Bethy. Good morning. Anyway, I'm still going to give her a round of applause for joining. I want to give everybody in the chat watching a round of applause for waking up for coffee time because we're going to go through this federal case. But before I go into it, we lost, and I'm just devastated. 2 of our main chiefs passed away within the same month, and I'm completely devastated. And I just want to give a moment of silence to Wyatt Chief Herb and Wyatt Chief David Murphy. And my condolences I'm just so lost. They were with me from the very beginning of even establishing the tribe, and they're young brothers. And I want all our men and women to check your health. Check your health. It's so important. But I want to give a moment of silence for them. Okay, without further ado, let's get into what we're going to get into today. I am going over my federal case, and this is public information, but I want to make a clear statement so that we're very clear and everybody understand what I can and cannot do. And it's a lot I can do because all this is public information. So before I start reading these documents, I want to make something clear for everyone watching. Everything I'm about to read comes directly from PACER, the federal court system. And these filings are public records. They're not sealed. They're not public. They are publicly accessible. And anyone can download them because they are public records. I'm fully allowed to read them aloud, quote them, show them, and discuss them. Reading public court documents aloud is protected speech under the First Amendment. This is the same protection journalists, legal educators, and commenters rely on every day. There's also something called the fear report privilege, which protects people who accurately quote and describe official court filings. As long as I read these documents truthfully, I'm protected. Speaking about public records is not the same as republishing private information. I'm not uploading documents, posting addresses, or creating written copies. I'm simply reading and commenting on public filings, which the law treats as protected commentary. What we're talking about today is government conduct, public employment, disability rights, workplace retaliation, and federal procedure. All are matters of public concern. That means this live stream receives the highest level of First Amendment protection. And because I live in Connecticut, the anti-SLAPP, SLAPP law also protects me from any attempt to intimidate or retaliate against me for speaking publicly about my case. So with that said, let's get into the documents. Shout out to everybody in the chat. Throw up fire. You are going to learn and you are going to see and understand what I've been going through. And I stay silent. I always stay silent, okay, about things. But I have to teach the public. And this isn't just for people from my community. This is for every United States citizen to learn. I don't give a damn what your race is. As long as you are a United States citizen, you have the same rights and protection as me. And this is something that people, not just me, citizens, period, in the United States, experience in their workplaces. Okay? So this is who this is for. And I know you're all out there. I hope you have your coffee. I hope you have your tea, whatever. But let's get started. So let me do a share screen. Oh, that's the wrong thing. Share screen. The entire screen.
So this was filed last year is
Oh,
when
wait a minute.
you
Wait a minute, honey. I don't have the document up.
Okay.
Hang on. I don't have it up. Okay. Let me pull it up. First, this is the docket. But we don't need to do the docket. So let's go straight to the complaint. Can everybody, it looks like everybody can see the complaint. I'm going to go to the very first page, and this is where this is going to start. I can make this bigger on my end, and everybody should be able to read it. Oh, I made it a little too big. I think that's sufficient for people who need to read. All right, honey, you can go and you can start from the top. United States District Court. Let's get it.
Okay, so United States District Court, District of Connecticut. This is for Bethy'S A. Giles, plaintiff, versus State of Connecticut Department of Administrative Services, which is DAS. Okay, so the state of, okay, so the defendants, do you want me to read their names?
Yes, it's public. It's all public information, and it's on the docket. This is open to the public. I mean, every news station, every news media has this. Journalists, they have this. They track things like this. But go ahead. So I'm going to read it. I'm media as well.
Okay, so not only is the state of the state of Connecticut, the defendant, but we also have Teresa Judge, DAS HR business partner 3, Darren Hobbs, Deputy Commissioner and Director of Regulatory Compliance, Ashley Dempsey, HR Generalist 3, Peter Zvingelis, Assistant Director of Regulatory Compliance, Omaris Vasquez, State Building Inspector, Ashley Burke, HR Specialist, EEO Unit, Jordan Kubik, HR Specialist, EEO Unit, and Michael Fushi, Construction Services, Building Official Supervisor. Defendants in their individual and official capacities. So the next is proposed Fourth Amended Complaint for Employment Discrimination. Section 1, Plaintiff. Plaintiff Bethy'S A. Giles is brown-skinned American Indian female and a citizen of Connecticut who resides at your,
Yeah,
and
you don't have
section,
to do that.
yeah.
We already
Sec-
read all the defendants, so we can go
okay,
bypass all of that.
okay,
We already read them. That's just that when you're doing a complaint, you have to establish the jurisdiction, and
okay,
does this court have jurisdiction over these people? Blah blah blah.
okay, okay.
So
So let's go
you
down
can bypass that and go to section 3.
section 3. All right.
Correct.
Okay, section 3, legal basis. Plaintiff brings this action under the following federal and state laws to remedy unlawful employment discrimination, retaliation, and constitutional violations. Title 7 of the Civil Rights Act of 1964, 42 U.S.C. Sections 2000E for race, color, religion, sex, and national origin discrimination and retaliation. Age Discrimination of Employment Act of 1967, ADEA 29 U.S.C. Section 621 for age-based discrimination. Americans with Disability Act of 1990, ADA 42 U.S.C. Sections, what is
You
this?
don't even have to
One,
read those
okay,
sections
okay.
for
Okay,
disability.
so that is for disability, discrimination, interference with ADA rights, Family and Medical Leave Act, FMLA 29 USC 26, Section 2601 for retaliation and interference with federal protected
You
leave.
felt
I'm sorry.
okay.
Connecticut Family and Medical Leave Act for state level protection of medical leave rights, and in the
Yep.
42 USC 1983 for violations of plaintiff's First Amendment rights, including freedom of speech and petition.
Yep. Section 4.
Okay, so section 4 is acts complained of. The acts complained of this suit concern race discrimination, retaliation for complaining about discrimination based on race, color, religion, sex, or national origin, violation and interference with the Family Medical Leave Act, age discrimination in employment, violation and interference with Americans with Disabilities Act, adverse employment actions, hostile work environment, emotional distress, violation of First Amendment rights. Okay, we're at section 5, basis of discrimination. The conduct of the defendants was discriminatory because it was based upon race, age, sex, requests for ADA accommodations, protected speech, and petitioning activity under the First Amendment, retaliation for filing internal and external complaints, ongoing hostile work environment. All right, now we're to the meat. All right, the nature of the case. Plaintiff Bethy'S A. Giles has been employed by the state of Connecticut since November 9th of 2001 on December 1st, 2016. She transferred into a Secretary 2 position with the Department of Administrative Services, the DAS. In 2017, she was reclassified as an administrative assistant after performing out-of-class duties. Throughout her employment, plaintiff consistently received satisfactory performance evaluations. Beginning in early 2024 and continuing to the present, plaintiff has been subjected to repeated discriminatory and retaliatory treatment by DAS officials based on her race, age, sex, disability status under the Americans with Disabilities Act, ADA, and protected activities. These protected activities include filing complaints with human resources regarding unequal job duties, compared to a newly hired white female secretary to age 27, filing 2 internal DAS EEO complaints in February and September 2024, and filing a CHRO complaint in March 3rd, 2025. Despite these complaints, discriminatory conduct persisted. As a result of raising concerns, plaintiff suffered adverse employment actions and was subject to a hostile work environment. These experiences caused significant emotional and physical distress, including depression, insomnia, loss of appetite, anxiety and panic attacks, headaches, increased medication use, elevated blood pressure, racing thoughts, emotional distress, and hospitalization. Meanwhile, younger white male and female employees who engaged in similar conduct, such as taking FMLA leave, were not disciplined or subject to similar treatment. The jurisdiction. This court has subject matter jurisdiction over plaintiff federal claims pursuant to 28 U.S.C. 1331, which is the federal question jurisdiction, 28 U.S.C. section 1343 A3, civil rights jurisdiction. Plaintiff's claims arise under the following federal statutes: Title VII of the Civil Rights Act of 1964, Americans with Disabilities Act ADA 42 U.S.C., Age Discrimination Employment Act ADEA, Family and Medical Leave Act FMLA, and 42 U.S.C. Section 1983. And I'll finish it. For a violation of plaintiff's First Amendment rights, including freedom of speech and petition. Jurisdiction is further conferred by 42 U.S.C. Section 2000 E5F, enforcement provision for Title VII, 42 U.S.C. Section 12117A, enforcement provision for ADA. This court also has supplemental jurisdiction under the 28 U.S.C. Section 1367 over related state law claims, including those arising under Connecticut FMLA, Connecticut General Statutes 31 through 51, KK to 3151 SS, as such claims form part of the same case or controversy as plaintiff's federal claims. Plaintiff has exhausted all required administrative remedies by filing charges with Equal Employment Opportunities Commission, EEOC, release of jurisdiction dated September 6, 2025, Connecticut Commission on Human Rights and Opportunities, CHRO, release of jurisdiction dated August 14, 2025. Section 6, facts of the case. Plaintiff brings this action under the following federal and state laws to remedy unlawful employment discrimination, retaliation, and constitutional violations. Title VII of the Civil Rights Act of 1964, 42 U.S.C., Sections 2000E, Age Discrimination in Employment Act of 1967, ADEA, 29 U.S.C., Section 621, Americans and Disabilities Acts of 1990, ADA 42 U.S.C. Section 12101, Family and Medical Leave Act FMLA 29 U.S.C. Section 2601, Connecticut FMLA, Connecticut General Statutes Section 31 through 51, KK to 3151 SS. 42 U.S.C. Section 1983 for violation of plaintiff's First Amendment rights, including freedom of speech and petition. Plaintiff asserts that defendants retaliated against her for engaging in protected speech, specifically for filing internal complaints and a CHR complaint addressing systemic discrimination with DAS. 1. The acts complained of in this suit concern race discrimination, retaliation for complaining about discrimination based on race, color, religion, sex, or national origin, violation and interference with Family Medical Leave Act, age discrimination in employment, violation and interference with Americans with Disabilities Act, adverse employment actions, hostile work environment, emotional distress, and violation of First Amendment rights. Number 2, the conduct of the defendants was discriminatory because it was based upon race, age, sex, requests for ADA accommodations, protected speech, and petitioning activity under First Amendment, retaliation for filing internal and external complaints, and ongoing hostile work environment. Plaintiff
Oh, they
was
can't hear you.
Plaintiff was subjected to continuous harassment and job sabotage, beginning in late December 2023 and continuing throughout 2024 and 2025 prior to intake meetings with DAS EEO investigators Ashley Burke and Jordan Kubik. Plaintiff requested that the sessions be recorded to ensure accuracy and completeness, giving their length over 2 hours. Despite no state law prohibiting such recordings and the routine recording of hearings and monthly meetings, her request was denied. Plaintiff followed up with an email inquiry, but was again refused. Her concern was that verbal only documentation will omit key details and misrepresent her claims. These adverse experiences led plaintiff to file 2 internal complaints with the DAS Equal Employment EEO unit in February and September 2024. Plaintiff provided sufficient time and documentation for defendants Ashley Burke, HR Specialist EEO, Ashley Dempsey, HR Generalist 3, Darren Hobbs, Deputy Commissioner of Real Estate and Construction Services, Jordan Kubik, HR Associate EEO, and Teresa Judge, HR Business Partner 3, to substantiate her claims of discrimination and retaliation and adverse employment actions. Despite this, plaintiff was not permitted to submit documentary exhibits to the EEO investigators or DAS Human Resources Management. Instead, the investigators relied solely on verbal statements and appeared to act in concert with regulatory compliance management. As a result, plaintiff escalated her claims to the Connecticut Commission on Human Rights and Opportunity, CHRO, which accepts documentary evidence in support of discrimination complaints. The EEO investigators contributed to a hostile work environment by refusing to accept written evidence and instructing plaintiff to hold off on the evidence. Both internal complaints were ultimately dismissed based on unsubstantiated findings. Plaintiff alleges that her constitutional rights, privileges, and protections under federal and state employment laws have been violated. The facts surrounding her claims include discrimination and retaliation based on race, sex, age, disability under the Americans with Disability Act, approved FMLA leave, protected speech, and petitioning activity under the First Amendment, hostile work environment, and adverse employment actions. These violations form the basis of plaintiff's claim under Title VII of the Civil Rights Act of 1964, the Americans with Disability Act, ADA, the Age Discrimination in Employment Act, ADEA, the Family and Medical Leave Act, FMLA, and 42 U.S.C. Section 1983, as well as related state law claims under Connecticut General Statutes Section 31 through 51 KK. Plaintiff possesses extensive documentation, including internal communication, meeting records, and procedural timelines that directly contradict the jurisdictions offered by defendants. These materials demonstrate a pattern of exclusion, retaliation, and discriminatory treatment that cannot be reconciled with DAS policies or federal and state employment laws. Defendants' reliance on verbal statements and refusal to accept written evidence further support the inference of bias and protest. Pretext.
Pretext.
I'm sorry. Claim 1, race discrimination. Supporting facts. I am a brown-skinned American Indian woman who has worked for the state of Connecticut since November 9th, 2001. I transferred to the Department of Administrative Services, DAS, on December 1st, 2016, and was reclassified as an administrative assistant in 2017. Beginning in early 2024, I was treated differently than white employees in similar roles. Danielle Hart, a white female secretary 2, hired in November 2024 to assist the state fire marshal and state building inspector, was promoted to a higher paying position and received more support and training. This promotion occurred in August 2025 after I filed a complaint in USC District Court for the District of Connecticut alleging employment discrimination. The defendants attempted to obscure the fact that they were grooming Danielle Hart to replace me and force me into retirement, despite the fact that she and I reported to the same supervisor, Peter Savingilis. My duties were reassigned to white employees without explanation, and I was excluded from meetings and communications essential to my role. I believe this disparate treatment was based on my race and age, and it was contributed to a hostile work environment and limited my professional advancement. Claim 2, age discrimination. Supporting facts. I am 40 years old and have worked in state.
I am over 40.
I am over 40 years old and have worked in a state government for over 23 years. Despite my experience and tenure, younger employees, including Danielle Hart, age 27, were treated more favorably. Hart was promoted and trained for my role. A suggestion made by Peter Savingilis, Darren Hobbs, and Amaris Vasquez. Even though I am not eligible to retire for another 6 years, I was excluded from professional opportunities and responsibilities that were routinely given to younger employees with less experience. I hold an MSW from the University of Connecticut and a BA in Criminal Justice and Legal Studies from the University of Hartford. This information is documented in my personal files and was known to management. The decision to overlook my qualifications and tenure in favor of grooming a substantially younger employee for my role reflects a discriminatory bias based on age. This pattern of exclusion and reassignment contributed to a hostile work environment and denied me equal access to advancement and recognition. Retaliation for protected activity. Supporting facts. I filed 2 internal DAS EEO complaints, February and September 2024, and a CHRO complaint, March 2025. I also requested ADA recommendations and took approved FMLA leave from October 4th to November 19th, 2024. After these actions, my duties were reassigned. I was excluded from meetings, and I received a disciplinary letter. I believe these actions were retaliation for exercising my rights. Claim for disability discrimination. Supporting facts. My doctor and therapist placed me on remote work under the Americans with Disability Act due to anxiety and depression caused by a hostile work environment. The only reason why I began seeing a therapist weekly was to cope with the workplace hostility. Prior to these issues, I had never required mental health services. Despite my continued ability to perform job duties remotely, I was excluded from meetings, stripped of responsibilities, and subjected to hostile treatment by DAS management. DAS failed to engage in interactive process or provide reasonable accommodation for my documented medical needs in violation of federal disability law. The exclusion and lack of support exasperated my condition and further contributed to the hostile work environment.
And
Legal reference.
these are all the legal references um for that supports me. And you don't have to read the codes. These are all federal, but you could just read what's in the bold, like Americans with Disabilities Act. You can read that prohibits. Go ahead, honey.
Okay, where do you want me to go down to? 5?
Legal, no, legal references. Americans
Okay.
with Disability Act of 1990 prohibits discrimination against qualified individuals with disabilities in all aspects of employment. And then
42.
yep,
Okay.
you don't have
42.
to read the numbers, but you can
Okay.
say 42
42
US code
USC. Okay. Oh, US code. Okay. Um,
requires.
12112 requires
You don't got to read
employers
those
to.
numbers, the section numbers.
Okay.
Like 42 US
Requires.
code requires employers. There you go.
Okay, requires
You
employers
got it.
to make reasonable accommodations for known physical or mental limitations of qualified employees. EEOC enforcement guidance or reasonable accommodation and undue hardship 2002 clarifies that remote work may be a reasonable accommodation under the ADA. Tulloch versus Connecticut recognizes that failure to accommodate mental health conditions in a hostile work environment may constitute disability discrimination under federal law. Claim 5, FMLA interference and retaliation. Supporting facts. I took approved leave under the Family and Medical Leave Act from October 4th to November 19th, 2024. Upon returning, approximately 62% of my duties were reassigned to an administrative assistant in the legal unit, despite my long-standing role supporting the Codes and Standards Committee and the Codes Amendment Subcommittee under the guidance of 3 staff attorneys in the legal unit since my hire on December 1st, 2016. I have constantly performed my duties without issue, and Commissioner Darren Hobbs, formerly my director and later promoted to Deputy Commissioner of DAS, had previously complimented my work. Other employees who took FMLA leave returned to their same positions without losing responsibilities, indicating that my reassignment was not standard practice. I believe DAS retaliated against me for exercising my rights under FMLA, and this action contributed to a hostile work environment and diminished my professional standing. Legal references, Family and Medical Leave Act grants eligible employees up to 12 weeks of unpaid job protected leave for specific medical and family reasons. 29 USC section 2615A1 prohibits employers from interfering with, restraining, or denying the exercise of FMLA rights. 29 USC section 2615A2 prohibits retaliation against employees for asserting FMLA rights, Was this Bekelder versus America West Airlines Incorporated? Okay, holds that
Hold.
adverse employment action taken because of FMLA leave may constitute unlawful retaliation. Pagel versus TIN Incorporated 695 clarifies that reassignment of duties following FMLA leave may support a claim of interference or retaliation if it materially alters the employee's role. Claim a hostile work environment. Supporting facts. I used to be able to view my management's calendars as admin in case I may need to reach out to them, but was blocked from viewing calendars, excluded from meetings, and stripped of responsibilities without notice. I was publicly humiliated, micromanaged, and undermined in front of colleagues. These actions caused emotional distress and insomnia, panic attacks, and hospitalization. The hostile environment lasted from late 2023 through 2025. Claim 7, unequal treatment compared to coworkers. Supported facts. White male coworker Paul Betty, Brian Mitchell, Timothy Murphy, Michael Devani, David Kopczynski took FMLA leave and returned to their same positions. Ashley Dempsey, a white female, took FMLA leave and was promoted. I was treated differently and held to a higher standard despite having more experience and education. Claim 8, biased investigations by DAS EEO unit supporting facts. In February and September 2024, DAS employment opportunity EEO investigators receive evidence I submitted in support of my discrimination claims, but disregarded its relevance and credibility. The investigators accepted statements from DAS management without scrutiny, while ignoring my documentation, which included first-hand accounts and supporting records. Investigators Ashley Burke, who publicly identifies as half Black, and Jordan Kubik, both white females, demonstrated bias in favor of management and failed to conduct an impartial investigation. The EEO units handling of my complaints lacked transparency, objectivity, and procedural fairness, undermining the integrity of the internal complaint process. This biased investigative conduct contributed to the hostile work environment and obstructed my ability to seek redress for discrimination and retaliation. Legal reference: Title VII of the Civil Rights Act prohibits retaliation against employees who file discrimination and complaints or participate in investigations. Farragers versus City of Boca Raton establishes that employers are liable for failing to prevent or correct discriminatory workplace conduct. Burlington Industries Incorporated versus Ellerth holds that employers may be liable for discriminatory actions when internal complaint mechanisms are ineffective or biased. EEOC enforcement guidance on retaliation and related issues, 2016, emphasizes that internal investigations must be conducted fairly and without bias to ensure compliance with federal anti-discrimination laws. All right, so I'm at claim 9. Retaliatory discipline based on false allegations, supportive facts. On May 27, 2025, a DAS employee, Michael Fushi, submitted a sworn affidavit alleging that I wore inappropriate clothing to a meeting held on January 6, 2025. I was wearing a regular blouse, an item I had worn to work on multiple prior occasions without issues, and was not informed of any concern or violation at the time of the meeting. Peter Savinglis issued a disciplinary letter based solely on Fucci's affidavit without speaking to me or allowing me to present evidence that I was not in violation of any dress code. I was denied the opportunity to respond to the allegation or to clarify the facts before the disciplinary action was taken. I believe this disciplinary action was retaliatory in nature and part of a broader pattern of hostile and discriminatory treatment designed to undermine my credibility and isolate me in the workplace. This is 11. Exclusion from Outlook calendars. Supporting facts. In September 2023, defendants Savingilis, Vasquez, and Hobbs blocked me from viewing their Outlook calendars. As an administrative assistant, I needed access to coordinate meetings and respond to inquiries from DAS Commissioner, Legislator, and Governor's Office. Blocking my access made it impossible to perform my duties and excluded me from daily operations. Danielle Hart, a younger white secretary too, was given access and treated as the preferred point of contact. Claim 12, unequal treatment after FMLA leave. Supporting facts. I took approved FMLA leave in October 2024 and returned in November 2024. Upon return, 62% of my duties were reassigned. White male coworker Paul Betty, Brian Mitchell, Timothy Murphy, Michael Devaney, David Kopchonsky, and white female Ashley Dempsey took FML leave and returned to their same positions without losing responsibilities. I was treated differently because of my race, age, and protected activity. Claim 13, interference by Vasquez in committee duties. Supporting facts. On September 7th, 2023, Amaris Vasquez expressed concern about my role supporting the codes and standards and CAS committees despite not being my supervisor. Vasquez interfered with my assignments related to the codes and standards hearing, which follow a step-by-step process developed collaboratively by the committee and staff council. She created barriers between me and new staff members, including Kimberly Rogers and Danielle Hart, disrupting professional relationship I had maintained for over 6 years prior to her and Peter Savingali's date of hire. Vasquez also influenced one or two committee members to participate in or condone her harassing behavior towards me. Despite my previously positive working relationship with those individuals, I was excluded from communications and treated less favorably than white employees in similar roles, contributing to a hostile and discriminatory work environment. 14, hostile email response while on vacation. Supporting facts. On September 19th through 2024, while I was on vacation, Vasquez emailed me to reserve conference rooms. I offered to help upon my return and suggested training Hart to assist. Vasquez falsely claimed she didn't know I was on vacation. Savingales responded with a hostile email criticizing me for not completing the task while on leave. 15, Claim 15, suggestion to replace without cause, supporting facts. In November 2023, during a biweekly meeting, Assistant Director Peter Svengalis and State Building Inspector Omaris Vasquez suggested training Danielle Hart, a newly hired secretary, to take over my entire job in the event of my retirement or absence. I had not indicated any plans to retire and was actively working in my role at the time. I held seniority over all clerical staff in my unit and consistently performed my duties successfully. The suggestion to train Hart for my position implied that management was preparing to replace me without cause, despite my qualifications to continue service. This conduct contributed to a hostile work environment and signaled a lack of respect for my experience and position. I believe this was part of a broader pattern of exclusion, age discrimination, and retaliation for asserting my rights and resisting discriminatory treatment. Claim 16, preferential treatment of white employees, supporting facts. DAS management, including Darren Hobbs, Peter Savingales, Omaris Vasquez, and others, consistently treated white employees more favorably than me, Daniel Hart, and Karen Salsi. Both white employees received support, inclusion, and harmonious treatment from management. In contrast, I was excluded from communication, managed, and subjected to harassing conduct, despite having more education experience than my peers. I hold an MSW from University of Connecticut and a BA in Criminal Justice and Legal Studies from the University of Harvard. These credentials are documented in my personal file, yet I never boasted about them and continue to perform my duties professionally. This differential treatment I experienced reflect racial bias and contributed to a hostile work environment that undermined my professional standing and well-being. Claim 17, biased EEO investigation supporting facts. In September 2024, DAS Equal Employment Opportunity investigators Ashley Burke and Jordan Kubik refused to consider the evidence I submitted in support of my claim of discrimination and harassment. They dismissed my documentation as irrelevant, despite its alignment with established case law and its direct support for my allegations. The investigators accepted statements from DAS management without scrutiny and failed to apply the same level of review to my materials. I believe the investigation was biased and designed to protect management rather than to fairly assess the merits of my complaint. This lack of impartiality undermined the integrity of the internal complaint process and contributed to a hostile work environment I experienced. Claim 18, interference with committee duties. Supporting facts. On April 18th, 2024, Deputy Commissioner Darren Hobbs and HR business partner Teresa Judge clarified my job responsibilities. They confirmed that I would continue supporting the Codes and Standards Committee, but removed my duties related to the Codes Amendment Subcommittee, CAS, and reassigned them to Danielle Hart, a newly hired Secretary 2, who is a younger white female. I had seniority over all clerical staff in my unit, and Hobbs and Judge disregarded my experience and qualifications in making this reassignment. I earned a Master of Social Work, MSW, from the University of Connecticut and a degree in Criminal Justice and Legal Studies from the University of Harvard. This information was submitted to HR and placed in my personal file. Omaris Vasquez, who was not my supervisor, repeatedly interfered with my assignments related to the Codes and Standards hearing, which follow a step-by-step process developed by the committee and staff council. My role in these hearings were essential to ensure the process ran smoothly, including building agendas and taking meeting minutes. Despite the clarification from Hobbs and HR, Vasquez and Peters Bengalis continue to interfere with my work during hearings, making it difficult to carry out my assigned responsibilities. Although I continue to perform my job effectively, their interference created unnecessary obstacles and frustration. It appeared they were still trying to learn both their own roles and mine while simultaneously undermining my position. I believe this interference was part of a broader pattern of harassment, exclusion, and discriminatory treatment. Legal reference title 7 of the Civil Rights Act of 1964 prohibits employment discrimination based on race, color, religion, sex, and national origin. Age discrimination and Employment Act protects employees over 40 from discriminatory employment practices. 42 U.S.C. prohibits retaliation against employees who oppose discriminatory practices and participates in protected activities. Farragher versus City of Boca Raton defines hostile work environment as conduct that is severe or pervasive enough to create an abusive working atmosphere. What is this, 19?
Yep.
Just 19, okay. Reassignment of CAS duties. On April 18, 2024, Deputy Commissioner Darren Hobbs and HR business partner Teresa Judge reassigned my duties related to the Codes Amendment Subcommittee CAS to Danielle Hart, a newly hired secretary too. CAS responsibilities were part of my core job functions since my assignment to the Department of Administrative Services. I never complained about these duties and consistently performed them without issue. I only experienced work-related strain when I was required to absorb the additional responsibility of 2 retired employees, the State Fire Marshal Secretary 2 and a processing technician who handled requisitions, without formal reassignment or support. Danielle Hart, a younger white female with less experience and no seniority, was given my responsibilities without explanation or justification. This reassignment diminished my role, contributing to a hostile work environment and reflected discriminatory and retaliatory intent. The decision to remove core duties from a long-serving employee without cause or consultation violated my rights under federal anti-discrimination and anti-retaliation laws. Legal references. Title VII of the Civil Rights Act of 1964 prohibits employment discrimination based on race, color, religion, sex, or national origin. Age Discrimination of Employment Act protects employees over 40 from discriminatory employment practices. 42 U.S.C. prohibits retaliation against employees who oppose discriminatory practices and participate in protected activities. Burlington Northern and Santa Fe Railway Company versus White holds that reassignment of duties can constitute retaliation if it results in materially adverse change in employment condition. Rees versus Sanderson Plumbing Products Incorporated, 530 U.S. 133 2000 supports that interference of discriminatory intent when an employer's justification is pretextual and inconsistent with the employee's record. Claim 20, humiliating oversight by legal unit. Supporting facts. On April 29, 2024, Deputy Commissioner Darren Hobbs, Assistant Director Peters Bengalis, and State Building Inspector Amaris Vasquez directed paralegal Tatiana Keating to verify whether I had posted meeting dates on Secretary of State's website. This task has always been a part of my responsibilities, and I had consistently completed it reliably. At the time, I was managing an unusually heavy workload due to the unfilled positions of two retired employees, the state fire marshal secretaries and a processing technician whose duties I had temporarily assumed. In prioritizing urgent tasks to maintain workflow continuity until a new secretary too was hired, I may have delayed posting the dates, but I remain committed to fulfilling all responsibility. The decision to publicly question my performance in this manner was humiliating and unnecessary, especially given my long standing record of reliability. I believe this incident was part of a broader pattern of harassment and exclusion designed to undermine my credibility and isolate me in the workplace. Claim 21, removal from fleet vehicle tracking. Supporting facts. On March 23rd, Hobbs assigned me to track fleet vehicles. I performed this task on July 2024 when Hobbs reassigned it to Karen Saucy without notice. Saucy was unaware of the reassignment until I informed her. I was excluded and undermined without explanation. Claim 22, blocking communication. Supporting facts. Kimberly Rogers, a white female manager, responded to my emails privately through Teams instead of publicly. This behavior suggests that she was afraid to acknowledge me in front of Vasquez and Savingales. It contributed to a hostile and isolating work environment. Claim 23, disrespect for management. Supporting facts. DAS management, including Amaris Vasquez, Peters Vangales, Teresa Judge, Dempsey, Kubik, Ashley Burke, and Darren Hobbs, consistently demonstrated a lack of respect for me in my role as an administrative assistant. I was excluded from meetings, stripped of duties, and treated as if I were disposable, despite my qualifications and contributions. White employees in similar roles were not subjected to this treatment, indicating a pattern of discriminatory behaviors based on race. The differential treatment I experienced contributed to a hostile work environment and undermined my professional standing. Legal references. McDonnell Douglas Corporation versus Green establishes the burden shifting framework for proving employment discrimination based on race. Texas Department of Community Affairs versus Burdine clarifies that discriminatory intent can be inferred from disparate treatment and a long legitimate justification. Farrager versus City of Boca Raton defines hostile work environment as conduct that is severe or pervasive enough to create an abusive work atmosphere. 42 USC Section 2000E through 2A1 prohibits employment discrimination based on race, color, religion, sex, or national origin. Claim 24, false narrative to force retirement. Supporting facts. Management created a false narrative to pressure me into retiring. I refused to leave and continued to assert my rights. Their actions were retaliatory and discriminatory. Claim 25, promotion of Daniel Hart. Supporting facts. On August 2025, Daniel Hart was promoted to the position of licensed application analyst. Hart received more training, support, and favorable treatment than I did, despite my greater experience and seniority. Since my return from FMLA leave on November 19, 2025, I have not been restored to equal responsibilities or the meaningfulness of my prior role. I was excluded from key duties and harassed, even though I had more experience and qualification than Hart. I believe this promotion and the surrounding treatment reflect discriminatory and retaliatory practices that undermine my career advancement. I performed my job 6 years before Vasquez and Savingales were hired. I consistently received excellent and very good evaluations, but after Vasquez and Savingales came on board, my evaluations were downgraded without justification. What's this? 26, claim 26, disciplinary letter based on false affidavit supporting facts. As part of the ongoing hostile work environment and retaliatory conduct on May 27, 2025, DAS employee Michael Bucci submitted a sworn affidavit alleging I wore inappropriate clothing to a meeting describing my blouse, which I had worn to work on several prior occasions without issue as a nightgown. The mischaracterization was used to justify a disciplinary letter issued without investigation or due process. The affidavit was factually inaccurate and selectively enforced, especially considering that human resources staff and other state employees regularly wear tongue rings, tattoos, physical piercings during work and Teams meetings without consequence. The affidavit's false and inflammatory nature submitted under oath raises serious concerns about its credibility and intent. While it may not meet the criminal threshold for perjury, it demonstrates a retaliatory motive and discriminatory enforcement of appearance standards, further contributing to the hostile work environment I experienced. Peter Svingalis issued a disciplinary letter based on that affidavit without speaking to me or conducting a proper investigation. When I asked Svingalis about the alleged screenshot, he stated, I do not have any of that information. I was not in attendance of the meeting and it was reviewed and determined by HR. I would reach out to them on this. Human Resources has not contacted me or provided any explanation regarding the disciplinary action. I believe this disciplinary letter was issued in retaliation and was part of a broader hostile work environment designed to undermine my credibility and isolate me. Legal references: Burlington Northern and Santa Fe Railway Company versus White. Retaliation includes any employer action that might dissuade or Retaliation includes any employer action that might dissuade a reasonable employee from engaging in protected activity. Farrager versus City of Boca Raton defines hostile work environment as conduct that is severe or pervasive enough to create an abusive working atmosphere. Kolstad versus American Dental Association clarifies that discriminatory intent may be inferred from reckless indifference to federally protected rights. Mount Healthy City School District Board of Education versus Doyle establishes that if protected conduct was a substantial or motivating factor in an adverse employment action, it may constitute unlawful retaliation. Claim 27, emotional and physical harm, supporting facts. The hostile work environment caused me anxiety, panic attacks, insomnia, and depression. I was hospitalized twice and continued to receive weekly therapy. My health had suffered due to the actions of DAS management. Claim 28, micromanagement of plaintiff only. Supporting facts. Omaris Vasquez and Peter Svengiles consistently micromanaged my work, but did not apply the same level of scrutiny or control to white female employees in the unit. My former directors and managers did not micromanage my work or express complaints. In fact, my annual performance evaluations consistently included positive feedback, including praise from Commissioner Darren Hobbs. Danielle Hart was allowed to coordinate meetings and carry out her responsibilities without interference or excessive oversight. I was harassed and questioned for taking time off, even though I had more accrued sick and vacation time than any other employee in my unit, including after returning from a 6-week FMLA leave. This unequal treatment contributed to a hostile work environment and reflected discriminatory and retaliatory intent. Claim 29. Collusion among management supporting facts. DAS management, including HR representatives Teresa Judge and Dempsey, Deputy Commissioner Darren Hobbs, Omaris Vasquez, Peter Svingiles Burke, and Kubik, colluded to undermine me. These individuals ignored the evidence I attempted to submit, reassigned my duties without justification, and contributed to the creation of a hostile work environment. Their actions were coordinated and targeted, reflecting a pattern of exclusion, retaliation, and discrimination designed to marginalize me and diminish my role within the agency. Claim 30. First Amendment retaliation based on protected speech. Supporting facts. Okay. Supporting facts. I am a YouTube partner and content creator affiliated with my newspaper company, Copper Colored Chronicles, and my nonprofit organization, neither of which is incorporated in the state of Connecticut or affiliated with my employment at DAS. My YouTube activity is part time, lawful, and conducted entirely outside of the scope of my state employment. I have never represented or spoken on behalf of DAS in any of my content. During the EEO unit investigation conducted by Ashley Burke, she referenced my YouTube activity and a fake letter sent to my employer by a YouTuber who disagreed with my comment. This letter was unrelated to my job duties and was used to discredit me. Burke refused to consider the evidence I attempted to submit and instead rely on irrelevant personal activity to justify adverse conclusions. I believe this constitutes retaliation for exercising my First Amendment right to freedom of speech as my content addressed matters of public concern and was created in my capacity as a private citizen. My YouTube channel, nonprofit organization, and newspaper has nothing to do with my employment at DAS. DAS management, including Burke, used my protected speech as a basis for harassment, exclusion, and reassignment of duties, actions that chilled my speech and undermined my professional standing. Legal references. First Amendment to the U.S. Constitution protects freedom of speech and expression from government retaliation. 42 U.S.C. 1980, Section 1983 provides a cause of action against state actors who violate constitutional rights. Pickering versus Board of Education 391 U.S. 363. Public employees retain First Amendment rights when speaking to private at Public employees retain First Amendment rights when speaking as private citizens on matters of public concern. Garcetti versus Cabellos clarifies that speech made outside official duties may be protected under the First Amendment. Okay, so we're at 31, claim 31, retaliation and hostile work environment following second internal EEO complaint. Supporting facts. After filing my first internal EEO complaint on February 22nd, 2024, which was deemed unsubstantiated, DAS officials, including Judge Hobbs, Svengiles, and Vasquez, continued to engage in hostile and retaliatory behavior. This pattern led me to file a second internal EEO complaint on September 23rd, 2024. Prior to the hiring of Secretary 2, Commissioner Hobbs requested a list of duties I had assumed from 2 retired employees, the Fire Marshal Secretary 2 and proceeding technician in legal unit in the legal unit. I provided this list as requested. On April 2024, I began to feel increasingly removed from the core functions of my role, which I had consistently performed since my transfer to DAS in 2016. I contacted HR representative judge to request a comparison of my job duties with those of Secretary 2. On April 19, 2024, I met with Judge and Hobbs to discuss my concerns regarding the reassignment of responsibilities, particularly by Fingales and Vasquez. Later that day, Judge emailed me a breakdown of duties, which, to my surprise, reassigned one of my core functions to Secretary 2 without explanation. Despite this reassignment, I was excluded from codes and standard CNS hearing meetings that I historically coordinated. Hobbs falsely claimed that I did not report to CNS, even though I had long worked directly with the CNS chair and committee members to coordinate hearings, agendas, and minutes. This exclusion was especially troubling given that Commissioner Hobbs had previously evaluated and complimented my work for both the CNS and CAS committees. While I was approved vacation from September 19th through 2024, Amaris Vasquez contacted me about reserving rooms for public hearings. I informed her I was on leave and offered to assist upon my return. I also asked if I could train Secretary 2 to handle the task, but Vasquez declined, saying that Secretary 2 was overwhelmed. Vasquez later falsely claimed to Svengales that she was unaware of my vacation despite having received my out of office message and replying to my team's message with "Have a nice weekend." Svengales, who had approved my vacation, confronted me about the incident. I reported this to Cubic as part of my second EEO complaint, but she instructed me to hold off on submitting supporting evidence. Upon my return from FMLA leave on November 19, 2024, Hobbs and Svengales called me into a meeting and handed me a document stating that effective immediately, the Codes and Standards Committee would be reassigned to the Legal Division of Real Estate and Construction Services. The document outlined my new duties as an administrative assistant within REX, which included logging and processing OSBI and OSFM modifications, assisting with 2023-2024 code section updates, performing general office tasks, examples given, ordering business cards, submitting BITs tickets, processing invoices, maintaining the construction help inbox for public inquiries, ensuring all work files were uploaded to the shared drive, completing my other duties assigned by my supervisor, Peter Svengilis, and managers reporting to him. On December 23rd, 2024, shortly after my return from FMLA, Cubic initiated another substantial investigation against me, mirroring the earlier pattern established by Burke. Legal references: Americans with Disability Act 42 prohibits retaliation and requires employment to provide reasonable accommodations for known disabilities. Family and Medical Leave Act makes it unlawful for employer to interfere with, restrain, or deny the exercise of FMLA rights or to retaliate against an employee for using FMLA leave. EEOC Enforcement Guidance and Retaliation clarifies that adverse actions such as reassignments of duties, exclusions for meetings, and unwarranted investigations may constitute unlawful retaliation. Burlington North and Santa Fe Railway Company versus White establishes that retaliatory actions need not be job termination or demotion. Any action that would dissuade a reasonable employee from engaging in protected activity qualifies. Gomez Perez versus Potter confirms that federal employees are protected from retaliation after asserting rights under anti-discrimination statutes. Tulloch versus Connecticut recognizes that failure to accommodate mental health conditions and subsequent retaliation may violate federal disability laws, Connecticut state laws, Connecticut Fair Employment Practices Act prohibits employers from retaliating against employees for opposing discriminatory practices or participating in investigations or proceedings. Connecticut Family and Medical Leave Act mirrors federal FMLA protections and prohibits retaliation for taking approved leave. Connecticut Whistleblower Protection protects public employees from retaliation for reporting unethical or illegal conduct.
Almost
Okay.
done.
Request for relief. Plaintiff respectfully requests that this court enter judgment in her favor and grant for following relief: race discrimination, compensatory and punitive damage in the amount of $5 million. Retaliation, compensatory and punitive damages in the amount of $5 million. Violation of the Family and Medical Leave Act under federal and Connecticut law, damages in the amount of $2 million. Age discrimination in employment, damages in the amount of $1 million. Sex discrimination, damages in the amount of $1 million. Violation of Americans with Disability Acts, damages in the amount of $1 million. Intentional and or negligent infliction of emotional distress, damages in the amount of $2 million. Reimbursement for legal fees, hospital and medical expenses in the amount of $5,000. Hostile work environment, damages in the amount of $10 million. Educational cost and student loan relief in the amount of $500,000. Equitable declaratory and injunctive relief, including but not limited to reinstatement of duties, removal of retaliatory disciplinary records, and implementation of anti-discrimination training and oversight. Any and all relief that the court deems just, proper, and within its authority to award. Jury demand pursuant to Rule 38 in the Federal Rules of Civil Procedure, plaintiff hereby demands a trial by jury on all issues so triable. Respectfully submitted, Bethy'S A. Giles.
So, let me get back to where you are, my dear. You did a wonderful job reading this. You made it. You're outstanding.
Thank you.
I mean that to my heart.
Thank you, Sister
So,
Betty. That was that's really interesting and very thorough. So,
yeah. So let me turn my camera on. So that was my complaint. And shout out to everybody in the chat room listening. Hey, Libra Sun, OJ Lady Moon. Shout out to everybody in the chat room. I sincerely appreciate everybody listening in. Now, that was the complaint. The next thing I'm going to read is the defendant's motion to dismiss. And it gets really funky, you guys, but that is my general complaint. And as a matter of fact, that was my fourth amended complaint. Okay. I amended my complaint 4 times. because every time I thought of something, I was like, oh God, I forgot to add this. Oh God, I forgot to add that. And the judge, they grant you, everything was granted. But what I want to show you, I think what I would do is take a 60-second break, because I'm going to actually read the state's motion to dismiss. It's strictly boilerplate. It's very weak. It's the weakest, it's one of those things where, they filed a boilerplate motion to dismiss, and they tried to get it dismissed on technicalities, but there's no technicalities from what I analyzed, but I'm not the judge to make that, decision and call. But they, instead of addressing the issues alleged in my complaint, they reverted filing a motion to dismiss my complaint, and they tried to get it by technicalities. And I'm going to read that to you. So after they filed their and I'm going to read it, and it's long. And after they filed their motion to dismiss, I filed my opposition in their motion to dismiss. And it was at that point where I uploaded 300 exhibits to the docket to substantiate everything that I said. And it was their own information. Now, I can only speak about the content that's on the docket. I can't speak about content that's not on the docket. Now, my 300 exhibits are on the docket, and they were accepted by the judge. So it's more like, you guys, it's more like when they filed the motion to dismiss. And I'm going to say this because it's about me. It's more like, oh, we'll just get around some technicalities. This shit'll go away. But see, that's what happens when you have someone in state government working for so long, and the educational tools that you take pay off. And it might not pay off in the beginning, but in the later years, they do. And it's one of those situations where I say in my own brain, I'm not fucking Dred Scott. That was my attitude. I'm not fucking Dred Scott. And everybody knows who Dred Scott is. He was not allowed his freedom. And in his situation, Dred Scott didn't have anyone to represent him. He didn't have, he couldn't read, couldn't write. So how can he fight in a federal court? Honestly speaking. And see, I'm going to use potty language because I'm speaking to a large audience from my community and all over the United States. It's more like sleeping one of the most powerful beings in the office. And it's more like having an attitude, oh, this will blow out. It's in federal court. Dumb bitch. She don't know shit. She don't know shit about no fucking law. She can't file no laws. She don't know what the fuck she's doing. Now, I know because, prior to state government, I always told you guys that I was a paralegal for 22 years. And back during that time, it was freelance paralegal. And I worked for a lot of attorneys, a lot of Jewish attorneys, and drafted a lot and traveled and took depositions, in my younger years. So it's more like this nigga don't know shit. This is how I felt internally after all giving my life to state government. Dumb nigga. She don't know shit. And we're always viewed that way, as dumb, don't know a damn thing. Oh, she's in court. She's going to represent herself. First of all, you damn right I'm going to represent myself pro se. And like I said, I'm not Dred Scott. I understand federal rules of civil procedure. It was a little shaky in the beginning because I had to get used to things all over again because, I'm not working in the actual court system. And a lot of things changed, but it's easy for me to catch up on, once I came in and started doing the research and started pulling things. And I said, our ancestors And most people never have attorneys that will represent them in this manner. They're all sold out. And I said, the only way I'm going to be able to get the representation that I need is to represent myself. Because, when I was working, doing a lot of work for the attorneys, I sat in the background and, I was in the courtroom, but I always sat and I just watched. You get your best learning from observing. And of course, I had the degree in legal studies and research, legal research and writing. I do maintain that degree today from the University of Hartford, and I've always used my legal skills. So I said, excuse my French, I'm not hiring no fucking attorney to fuck up my case because nobody can explain what I went through but me. And they're not going to do it right. And I know it. I was already told, you fight like a seasoned attorney of 40 years, and they still can't get some of the things right that you've done, Miss Giles. Sur Replies. And you're going to see that don't even get granted by judges because seasoned attorneys literally don't know what the purpose of a Sur Reply is for. But you did, Miss Giles. I refuse to get an attorney to represent me. I refuse to let anybody lowball me. I am fully armed to go straight to a jury. That is the easiest part. Discovery, after the motion to dismiss ruling, discovery all the way out is easy and gravy for me. I have no problem proving with the exhibits. And you're going to see the exhibits because I'm going to show them to you because they're on the docket, public information. And see, when I uploaded the 300 exhibits on the docket after I completed my opposition to their motion to dismiss, that shake the fucking heavens. Because in their head, how did this bitch keep information from 2016 all the fucking way up to 2020, 25? When you're the quiet, humble nigga that got to sit quietly, these are the things you do. You continuously underestimate us. You look at us as arrogant niggas that don't know a goddamn thing. But this is a different nigga. A different nigga. And to all of you sisters and brothers in my community and watching today, let me tell you something. You speak about, y'all getting these government positions and you don't give back and you don't do this. You don't know what the fuck we go through in our employments. You're reading this full-fledged. I've been working out of my class since 2016. It's more of a situation with and I'm going to say use my words because it's how it makes me feel. Speaking within the docket, my internal thought. You fucking educated nigger. You can do the work, but you'll never get the fucking title or the fucking pay. You stay quiet, nigger. You do your job. But at that point, I had a baby. My baby was only 5 years old. After a certain amount of years, I knew I had to take care of my baby. However, she's 34 now. And I knew I had to keep my job. And that's the situation that I've been. But you know what? Just because I'm brown, American Indian, like it says, I'm not the only one who suffers this in state government. This happens to all races of people in state government. And I hope that their eyes are open to understand where to go to get their civil rights protection, First Amendment protections. Federal court. Now, I don't know the judge, but one I do know about federal judges, and it seems uniform across the states. Federal judges are very different from state court judges. Federal judges have zero tolerance. If you don't want to, the people you don't want to upset in litigation are federal judges. They don't fuck around with people. They're very serious because they're lifetime appointments. They have zero tolerance for bullshit. And that's across the board. I don't know my current judge. I just seen a few videos that they had where they was humiliating her before she got appointed. I thought it was fucked up what she went through, some bullshit. But I don't know her. I don't know any federal judges, but I do know from, reading and looking at court cases, they don't fucking play. They don't. And they give the scariest scrutiny ever. That's what I know about federal judges. They don't. So let me take a 60-second break, play a little music, and then I'm going to read the defendant's motion to dismiss. And Isness, thank you so much. I appreciate you so much. I'm going to take a 60-second break, play a little music, and get their motion weak ass. They learned that their motion to dismiss was fucking weak after I uploaded the 300 exhibits to the docket. Now, in federal court, when determining the motion to dismiss ruling, a federal judge cannot weigh evidence. They strictly have to make sure all the claims must be plausible. They can't weigh evidence or use the exhibits, because if they do use the exhibits now, they have a choice to use the exhibits, but it's their personal choice. If they use any of the exhibits, it immediately has to be converted to a summary judgment. Okay, but we're not even going to go there. I don't know the mindset of this judge. I don't know her personally. I don't know how she operates. I only, like I said, saw that video where they interrogated her when she got appointed, but that was it. She looked like she might be about maybe 32, if that. I don't know. She's very young, pretty lady, but I don't know. I don't know. And it's up to her. I'm not a judge. It's up to the federal judge, and what the federal judge, how she rules, it stands. Bottom line. So let's take a 60-second break from this. That was a lot of reading. It was 36 damn pages. Huh? What do you think, Isness? What are your thoughts so far, Isness?
Well, I am proud of you, Sister Bethy, for taking it upon yourself to do this without the attorney, because you're right. A lot of times, first of all, attorneys don't want to take the case. Second of all, they don't know your story like you know your story. And so you were very clear, you were concise. As I'm reading it, I could follow along. I could see what the issues were very clearly, very easily. So you did a great job. This was nice.
Thank you very much. I appreciate it. It was really, took a lot of work. I could tell you it took a lot of work. I'm telling you, I lost a lot of sleep putting that together. 36 pages. And it was tough. It was tough in the sense of when you're writing a complaint, every time you re-amend it, you live through it. Literally, you live through the treatment. Now, to back it up a little bit, these people that are doing this to me, they didn't come in to state government employment until 2023. So I've fucking been doing my job by myself before they came, from 2016 all the way until they came. And then it started swiping it away from me in early 2024. And they're thinking I'm going to retire. I'm like, wait a minute. What the fuck am I going to retire for? I can't retire for 8 years. I'm not old enough. This was at the time when they came. No, if you count back to 2023, So I'm going to pause right here, play a little music for like 60 seconds, drink some water, and then I have to start reading their weak ass motion to dismiss. And the Attorney General is currently representing them. So I'll be right back, you guys. All righty, everybody, let's get it. I told y'all this was gonna be long, but it's observable, and this live will be up for people to rewatch and have fun. You know, so they say when people hate you, they're your best motivators, and I got a lot of them. I don't have to jump up and prove, you know, say this and say that. I'm just, y'all know me. I'm just gonna show the fucking proof. That's it. Everything else is, hella dead. So let's get it, you guys. Where's my share screen? Ooh. Let me see, am I doing this right? I never do shit right. So, okay. So that's the complaint. I can get rid of that. Let's go to the actual docket. This is the court docket. I just copied it. I didn't feel like I just downloaded the actual docket. As you can see, this is the court docket that people track, the news media and everybody chat. Now, when I first started my case, there was an attorney general, Talasi Brooks. She was the assigned attorney general, but then after a year, she resigned, and they put in another attorney general who is currently, see where it says Talasi Brooks and it says terminated. She left June of this year. So she worked on a case defending the defendants, assistant attorney general. worked defending the defendants. She let from the day I filed my case, and she quit her job. I don't know, went somewhere else. I don't know. I don't work in the AG's office, and I could care less. But she resigned from representation and I guess went somewhere else. I don't know. But then the new attorney general was assigned. She's the lead attorney, now taking over representing the defendants in the docket. And they're listed on the docket as such. My complaint was filed originally on August 21st, 2025. But I kept amending it, of course. So now we're down to reading the motion. It's long. This docket is 121 entries. The last entry I uploaded is a notice. Let's see. First notice 29. My way on the last page. Oh, a notice. And this notice that I uploaded on the document recently on July 29th, it's called Arming the Judge when new law comes down from the 9 Supreme Court justices. And the newest law is the Roper Bright Enterprise versus Raimondo ruling from the 9 Supreme Court justices, which ordered all federal judges, they could no longer, when making their rulings, go by state agencies' policies and state agencies' interpretations of statutes. That federal judges must use their own individual interpretations using only federal law, constitutional law. So now the rulings are no longer in favor of states bullshit. So we are more protected as U.S. citizens in federal court because they can no longer go by agency bullshit, state agency bullshit. So I made sure that in my case, everything was federal law, constitutional law, federal statutes. That's all I used because it's the highest, and I used the most recent. So I can stop with this. Hopefully this changed. So here's their 71-page motion to dismiss. I'm going to skip through a lot. Oh, no, I'm sorry. This is the CHRO. I don't need the CHRO. But I'm going to have to stop the share screen because I thought I pulled up their motion to dismiss, and I didn't. I literally thought I did. So forgive me, guys. Give me a minute, and I will pull it up. I need this docket. Give me a minute. I'll pull it up now. Just give me a short minute. I'm so sorry, but I want to read their motion to dismiss, which is weak as fuck. But let me give you a little music while I'm getting that motion, their motion to dismiss up. Media assets. I apologize again for this. Okay, we're on the ball now, you guys. Let's get it. Oh, ooh, ooh, ooh.
And this is their response when you filed your complaint?
Well, they didn't respond to my complaint yet. They filed a motion to dismiss. They're trying to, and that's a
Avoid.
tactic to avoid, So, all right, hey,
Okay.
Ladette, whatever. Um, all right, so let me know if you guys can see this. Can you see it, sweetheart?
Yes.
Okay, I'm gonna make it big on my end because I know I'm a blind bat. Okay, so I'm not going to read the defendants. We know who the defendants are, and I am suing them in their individual and official capacity. Okay, welcome to the chat, everybody. Good morning. I'm reading now the defendants. This is their defense. Instead of addressing my complaint, they vowed for a boilerplate motion to dismiss to see if it'll work. So it goes. In this action, plaintiff B. Giles sues her employer, defendant state of Connecticut, of administrative services, along with 8 DAS employees in their official and individual capacities for alleged discrimination and retaliation violation. And they're naming all the things that I'm screwing age. She also asserts a claim of intentional infliction of emotional distress as well. Plaintiff claims concern ordinary workplace interactions in job directives, and she has alleged not facts linking any purported action she experienced to any protected status or protected activity. Oh, really? Wait till the opposition comes, you guys. Now you're saying they're saying I didn't do this. So plaintiff claims against DAS and official capacity defendants are barred by the 11th Amendment immunity, and the ex parte Young exception does not apply on the facts pled. The court also lacks jurisdiction to consider the plaintiff's Title VII, ADA, and ADEA claims against individual defendants in their individual and official capacities because those statutes do not provide for individual liability. Plaintiff also failed to adequately plead the remaining section 1983 Title VII FMLA, Connecticut FMLA, and intention of infliction of emotional distress. That's what IED stands for. In addition, plaintiff failed to exhaust her ADA claim as well as claims regarding certain challenged actions. And she cannot challenge any adverse action that occurred more than 300 days before the filing of a complaint with the Commission on Human Rights and Opportunities. Defendants respectfully request that the court dismiss this matter entirely. A memorandum of law, which more particularly sets forth the grounds for dismissal, accompanies this motion. Wherefore, defendants respectfully move this court grant its motion to dismiss plaintiff's complaint. And that's the certification. So then we get to their index, what appears their table of contents of the memorandum of law. I don't have to read any of this. This is all garbage. But then we go to, let's get to the meat of their complaint. That's weak as hell. And you'll come to know this. In this action, plaintiff Bethy sues her employer, defendant state of Connecticut Department of Administrative Service, along with 8 employees in their individual and official capacities for alleged discrimination and retaliation. You know all what I'm suing for, so I'm going to skim through a lot of this. All the claims. I had 39 claims, okay? All federal. She also asserts a claim of intentional. We already read that. Plaintiff claims against DAS and official capacity defendants are barred by the 11th Amendment. I just read that. This is just a repeat. Procedural history. Here we go. Their story against mine. On April 9th, 2025, plaintiff filed a complaint with the Commission on Human Rights and Opportunities, alleging defendant state of Connecticut, DAS, discriminated and harassed her due to race, age, sex, and retaliated against her for her complaints about discriminatory misconduct. Plaintiff's CHRO complaint did not include a disability discrimination claim or claim disability as one of her protected classes. Plaintiff obtained a release of jurisdiction from CHRO on August 14 and a release of jurisdiction from EEO on September 6. The plaintiff did not name any of the 8 individual defendants as respondents in her April 9th CHRO complaint. They are hilarious. On August 2025, plaintiff served DAS with an initial complaint and summons in the matter. On or about August 29th, the plaintiff filed an amendment complaint. Yep, I did. The court granted this motion on October 1st. On October 2nd, plaintiffs filed a second amended complaint, which added individual capacity claims for all 8 official defendants. Then on October 10th, plaintiff filed a motion for leave to amend the second amended complaint. The court granted the plaintiff's motion on October 2nd, 2025. Plaintiff filed a third amended complaint on October 23rd, 2025. On November 11th, 2025, plaintiff filed a motion for leave to amend a third amended complaint. On November 12th, 2025, the court granted the motion for leave to amend the third amendment complaint, which I was in my right. Plaintiff filed the fourth amended complaint on November 13th, 2025, which is what American Isness is. This is the active operating complaint. The fourth amended complaint alleges 31 claims for relief for violation of United States 42 of United States Code 1983, blah, 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 the Civil Rights Act. We know all the claims. Family Medical Leave Act. I can skip through all this. The individual and official capacity defendants, Teresa Judge, Darren Hobbs, Dempsey, Zavingalis, Vasquez, Burke, Kubik, and Fucci. Fourth Amendment complaint. The fourth amended complaint does not specify which claims are asserted against the defendant, and it sure does. Plaintiff alleges defendant Teresa Judge and HR, business partner 3. Plaintiff alleges defendant Darren Hobbs is the deputy commissioner, real estate construction services. Plaintiff alleges defendant. Okay, we know all the defendants. We don't have to read that. Let's get to the meat. So here's their little factual background. The plaintiff alleges that she is a brown-skinned American Indian woman who is over 40 years old. She has worked for the state of Connecticut since November 2001. Fourth amended complaint, she transferred to DAS in 2016 and was reclassified as an administrative assistant in 2017. Plaintiff's allegations of harassment, hostile work. Plaintiff alleges that in September 2023, Zavingalis, Vasquez, and Hobbs blocked her from viewing their Outlook calendars. Plaintiff alleges a secretary to Daniel Hart was given access. Fourth amendment complaint. Plaintiff alleges Vasquez interfered with her assignments and engaged in harassing behavior towards plaintiff. Plaintiff does not describe the purported harassing behavior or provide any examples or specific information describing how Vasquez interfered with assignments. Plaintiff only alleges that a colleague, Kimberly Rogers, responded to plaintiff's emails via Teams instead of publicly, which plaintiff interpreted to mean that Rogers was afraid of acknowledging plaintiff in front of Vasquez and Zavingalis. Plaintiff alleges that Zavingalis and Vasquez interfered with her work during hearings without providing any examples. Plaintiff alleges Vasquez and Zavingalis consistently micromanaged her work without providing examples. Plaintiff alleges in November 23, during a bi-weekly meeting, Zavingalis and Vasquez suggested training Hart to take over plaintiff's job in the event of her retirement or absence. Plaintiff alleges that on September 19 to 20, while she was on vacation, Vasquez emailed her to reserve rooms. Plaintiff offered to help upon her return from vacation and suggested training Hart to assist. Plaintiff alleges Vasquez falsely claimed she didn't know I was on vacation and Zavinglis responded with a hostile email criticizing me for not completing the task while on leave. Plaintiff alleges she performed her job for 6 years before Vasquez and Zavinglis came on board and consistently received excellent and very good evaluations. But after they came on board, her evaluations were downgraded. Plaintiff does not allege that she has never received an unsatisfactory performance evaluation. Plaintiff does not allege who conducts her performance evaluations. Okay. Plaintiff alleged that sometime prior to April 2024, she had assumed the additional responsibilities of 2 retired employees, the state fire marshal, secretary 2, and a processing technician 2. Plaintiff alleges in April 2024, she delayed posting meeting dates for the Codes and Standards Committee on the Secretary of State's website due to her usually heavy workload due to the unfilled positions of 2 retired employees, which is true. Plaintiffs alleged that on April 29th, Hobbs, Zavinicas, and Vasquez directed a paralegal to confirm whether she had performed one of the duties for the Codes and Standards Committee, posting meeting dates on Secretary of State website, which she admits she had not done. Plaintiff alleges that on April 18th, Hobbs, the judge, gave her a breakdown of job duties at her request. Plaintiff alleged Hobbs and judge confirmed she would continue supporting the Codes and Standards Committee, but remove job duties she had been performing related to the Codes and Standards Codes Amendment Subcommittee and reassign them to Hart, who had been hired to assist the state fire marshal and state building inspector. Plaintiff alleged she took approved FMLA leave from October 4th to November 19th, 2024, shortly after her filing her second EEO complaint. Upon returning, plaintiff alleged approximately 62% of the duties she had been performing were reassigned to administrative assistant and legal unit. Plaintiff does not allege which duties were reassigned. This is a joke. Plaintiff does not allege which duties she had been performing prior to the reassignment or which duties she had been performing before absorbing the retiring employee's duties. Plaintiff separately alleges that on November 19th, Hobbs and Zavinicas reassigned the Codes and Standards Committee to the legal division of real estate and construction services. So they're basically typing everything that I allege. Okay. Plaintiff, they're repeating everything I said, literally, you guys. That's why I'm not going to read 49 damn pages. I'm just going to get to the meat. And then they're going to write the law to survive a motion to dismiss. The complaint must contain sufficient factual matter accepted as true to state a claim to relief that is plausible on its face. Ashcroft, they tried to use the law I used. Child, let's get it. Plaintiffs must do more than plead facts that show a possibility of defendant acted unlawfully. Okay. The court must accept allegations. Basically, their motion to dismiss is telling the court what it's supposed to do. The court must accept the allegations in the complaint as true and draw all reasonable inferences in the light of most favorable to the non-moving party. However, their thread bar recitals of the elements of the cause of action supported by mere conclusory statements do not suffice. A pleading that tenders naked assertions devoid of further factual enhancement is insufficient. Under Federal Rule of Civil Procedure, a pleading must contain a short and plain statement of the claim showing that the pleader is entitled to relief. As the court held in Womley, the pleading standard Rule 8 announces does not require detailed factual allegations, but it demands more than an unadorned, the defendant unlawfully harmed and me accusation. A pleading that offers labels and conclusions of formulaic recitation of the elements of cause of action will not do, nor does the complaint suffice its tender. So if that's the case, why didn't you respond to the motherfucking complaint? Hello, y'all.
They want to dismiss because they don't like the way you wrote the complaint. Is that what they're saying?
Girl, it's a hot mess. Basically. And they don't want to answer it because if they do, you don't know, how I'm armed. It's a hot mess. Of the 10 statutes, and common law, plaintiff indicates DAS and official custody defendants have violated the court only has jurisdiction to review her complaint violates Title VII Civil Rights Act. Yet the Fourth Amendment complaint fails to adequately allege a claim of release against DAS for violation of Title VII. Did I just not read? Did you just not read all my claims of relief?
Can you repeat that?
Did you just not read all my claims for relief?
Right. Yep.
The last of the document.
Right.
So they're saying I didn't do that. So all they're doing, the 11th Amendment of the U.S. Constitution provides that judicial power of the United States shall be construed to extend to any suit in law or equity, commenced or prosecuted against one of the United States by citizens of another state, or by citizens or subjects of any foreign state. In addition, its explicit restriction of suits by citizens of another state. The 11th Amendment has been construed to protect an uncondensing state from suit by its own citizens. 11th Amendment immunity is not absolute and can be waived in either of two ways. First, a state may waive its sovereignty immunity and agree to be sued in federal court. Second, Congress may abrogate a state's sovereign immunity, unequivocally express its intent to abrogate the immunity, and two, acts pursuant to a valid exercise of power. The 11th Amendment bars action for money damages against individuals in their official capacity. Right, official capacity. But don't forget about individual. But we gonna get there. Because such an action is essentially a suit against the state itself. Correct. So all they're doing is explaining all the laws that I wrote and all the laws that stand behind me. And what this is blah, blah, blah stuff. I'm not going to take you guys through this. I can't do it. I can't even do it. Not even to my worst enemy. But it's just a bunch of blah, blah, what I can't do. So now I'm going to read the damn opposition on how I came back. This is moot as far as I'm concerned. But I'm not the federal judge. I am not the federal judge, but I'm not going to sit here and read y'all 50 pages of bullshit. Okay? So let's go to the my opposition, you guys. Let me
you are not obligated to stop at the administrative level, which is the EEO was it EOC? Is that what it's called? You have a right.
I already went to them.
Yeah, you already went to them and they didn't hear it. That's just an administrator. You have a right to go to a judge. And
absolutely. But you do have to exhaust your remedies first.
Right.
You do have to go to CHRO.
Right. They're trying to say that this judge doesn't have jurisdiction, right? And another thing that they're trying to say is time limit, right? You did complain within that time. They made their decision and now you're moving on. Like you just said, I exhausted all my avenues with the protocol, right? And so now I'm moving forward. Well, you did what you're supposed to do. You did make that complaint within the time limit. So so that one's another moot point, as you said.
Exactly. So let's get plaintiff's opposition. Oh, plaintiff's opposition. Oh, here it is. Boing, boing, boing. I had to pull it up, you guys. This is it. I think this is it. Yes, truthfully it is. So let me read this. Oh, no, that's only 6 pages. That's not it. Oh, here it is. Hang on, you guys. Give me you can keep talking, honey. I thought I had my opposition up, but I got it. I'm do. It's a hot mess. Plaintiffs propose.
they're trying to say that, so I'm looking up 11th Amendment, and it says the amendment restores the idea that a state cannot be sued in federal court without its own permission.
That's true, but they forget about individual casting, and there's certain things that they are not amended to, and I break that down in my opposition.
Okay.
Um, okay, where the hell are we?
It says that an individual can can sue state officers to stop them from breaking federal law, and that's what you're doing.
Right, I'm looking. Where is my? See, I had all this up motions. That's them. This is me. Is this it? No, that's not it. I got it, you guys. Give me a minute. Jesus. Sister Bethy. Those are exhibits. Let's get to the fire part. Where the hell? All right, plaintiffs. Maybe, okay. Sur Reply. Those are Sur Replies. Read about opposition. It's got a proposed. Plaintiffs propose. That's Sur Reply. I don't want that. That's that. It's probably down here buried. That's Sur Reply. Um, Scheduling order. Oh, here it is. That's why. Damn. Um, Exhibit A. Jesus. Um, Stay. Y'all go get y'all's coffee. Opposition to defendants. Support motion to oversize. Defendant. Sur Reply. Why?
I'm looking
Is the
up
damn
the law, and you did exactly what you were supposed to do. It says that you're supposed to do specific legal pathways, and you exactly did it. And then you moved on to go to file a petition for court. So, eggs in their face. You did exactly. They can't say, "Oh, the time limit." No, the reason why the time limit has passed since such since the injury basically is because you went through the EEOC, you went through the proper channels, right? And that's what you
facts?
absolutely have to do before you can move on.
Facts.
So you go, Sister Bethy.
Oh yeah. I'm just so pissed. I guess because I've been doing so much. Um oh, here it is. God, I got it. Damn, Bethy. Opposition to here it is. You know what? I'm just gonna up this way. I'll pull up these two. That's one. And I'll pull up this one. Two. Oh, that's the exhibit. And then what's this? Oh, two. So a petition. No, you know what? I don't want to do that. I don't want to do that. It's how many? Oh, here it is. All right, all 32 pages. Here we go. I'm sorry. All right, so here's how they come for their butts. Let's get back to the. Is my chat still alive? Here we go, guys. Share screen. Oh, God. Come on, Bethy. Do better. Share screen. Entire window. This. It's just so much when you got to do. Ugh, it's a pain in the ass. Halo dead. All right. So here is my opposition to the defendant's motion to dismiss. Okay. You want to read or you want me to read? Hey, Buddha.
I could read it, but you have to do it the other way because my computer is lagging.
Okay, hold on.
Okay.
Here we go. All right. Is this it? It's just an 81-2. Which one is this? 81. This is 81. Okay, this is it. So, yeah, I think you'll like this one. This one's more fun. Boom, 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 boom. Fuck. All right, let me just get there. Can you see me sharing anything? Let me stop. To copper. Say the first letter of your thing.
Q.
Oh my God. Oh, it's Q?
Mm-hmm.
I thought it was
OPP. Or you could do
got
American
it.
Business. Yeah, okay.
All right, there we go. Here we go. Let me know when you got it. We coming, y'all. Wow, it's still lit up in here. Here we go. Let me know when you all right.
Okay, I'm pulling it up now. I'll wait for it to. 1 second.
I know, girl. You ain't even got to tell me. Let me know if my screen is sharing.
It's something about my Wi-Fi. It just does not like StreamYards. It just starts lagging. So that's the reason. So I'm just waiting for. Okay, I got the document pulled up. I'm ready. I'm ready to go. All right.
All right, y'all. Here we go.
All right. All right. So case. You want me to read the case law index or?
Is that
Oh,
what you
well,
got?
that's yeah. I got
No, it says 1 through 32 pages. It should be 32 pages.
this looks like it's 2 pages. Maybe let me go backwards. This is
Oh
2 pages.
God.
Hold on.
Let me see. Hang on, hang on. Ay, ay, ay. All right. This is a pain in the ass. One. All right. You know what? I'm going to send these two. It's easier this way. My bag. We coming, y'all. I thought I had these up. Q. There you go. All right. And it gives the page number. This should be much easier for you. That should be much easier for you. Hey, y'all hanging in there. She's coming. She got to wait till she get my email. We coming. They hanging in there for me. I love y'all. Let me know when you get it, honey.
Okay, I think I got it. Hold on. What is
Right.
this?
It's in 2 sections. I put it in 2 sections, so you'll do pages
Oh, okay.
1 through whatever. See it?
Okay, yeah. So I see where you sent 2 documents. All right.
Yeah.
So 1 through 16. All right.
Yeah.
Okay, so as you said, we know who the plaintiffs are.
Plaintiffs. Yep. Just read the title and let's get it.
Plaintiffs.
You don't have to read the numbers though.
Okay. All right. Plaintiff's opposition to defendant's motion to dismiss Fourth amended complaint. Introduction. Defendant. Motion to dismiss seeks to dispose of all 31 counts by invoking 11th Amendment immunity, sovereign immunity, and Rule 12 B6. Their arguments misapply controlling precedent and ignore factual allegations pled with specificity. At this stage, the court must accept plaintiff's allegations as true and draw all reasonable inferences in her favor. Ashcroft versus Escobar. Bell Atlanta Corporation versus Twombly, and Conley versus Gibson. It says, moreover, Congress has expressly abrogated state sovereign immunity in Title VII ADA claims, Fitzpatrick versus Blitzer, Tennessee versus Lane, and suits against state officials in their official capacities are not barred. Ex parte Young. Haffer versus Mello. Okay. Plaintiff has already submitted an independent Rule 26F report, ECF, documenting defendants' refusal to cooperate in discovery and identifying specific categories of withheld evidence. That report underscores the factual basis for plaintiff's claims and demonstrates why dismissed at this stage could be improper. Plaintiff's claims are viable and dismissal is improper. 11th
Okay.
Amendment.
So I want to
Okay.
make sure that, hold up, honey. I want to
Okay.
make sure the chat understands this. So I'm going to read it again so you can understand, because this is regarding them trying to fight against immunity. So it says, moreover, okay. It says defendant's motion to dismiss seeks to dispose all 31 counts by invoking 11th Amendment immunity, sovereign immunity, and Rule 12b6. Their arguments misapply controlling precedent and ignore factual allegations pled with specificity. At this stage, the court must accept plaintiff's allegations as true and draw all reasonable inferences in her favor. Ashcroft versus Iqbal, Bell Atlantic Court versus Twombly, and Conley versus Gibson. Moreover, Congress has expressly abrogated state sovereign immunity in Title VII and ADA claims. Fitzpatrick versus Bitzer, Tennessee versus Lane, and suits against state officials in their individual capacities are not barred. Yo, let's just go here for a second
And you
and
also
give
said
a
that
damn
you
bomb drop. I got to do a bomb drop.
okay.
So now y'all know that. So
Right.
let me get back to where we were. Okay. Plaintiff has already submitted independent rule 26F report documented defendant's refusal to cooperate in discovery and identifying specific categories of withheld evidence. That report underscores the factual basis for plaintiff's claims and demonstrates why dismissal at this stage would be improper. Plaintiff's claims are viable and dismissal is improper. So now you can take it from there. Argument, 11th Amendment.
And then I also thought I heard you say that you submitted like so much discovery. You submitted discovery already
No,
with your
well,
complaints.
I with my
Or
opposition, they were
okay.
loaded up after this because
Okay.
you don't really need to list all that. You got to put your claims in. But
Okay.
keep going. We'll get
Okay.
there.
Okay.
We're
So
talking about
argument.
11th Amendment immunity. There you go.
Okay. 11th Amendment immunity does not bar prospective relief. Defendants argue that sovereign immunity bars all claims, but under the ex parte Young suits for prospective injunctive relief against state officials in their official capacities are permitted. Plaintiff seeks reinstatement of duties, removal of retaliatory records, and injunctive oversight, all prospective remedies. Courts in this district routinely allow such claims. Vega versus Simple. Okay. Thus, 11th Amendment immunity does not bar plaintiff's claims for injunctive relief. As detailed in plaintiff's independent rule 26F report, jurisdiction is proper under Title VII, ADA, ADEA, FMLA, and Section 1983. Plaintiff has exhausted administrative remedies through CHRO and EEOC releases. Defendant's motion ignores this procedural history, which is already on the docket. Another bomb.
Oh, should I just continue dropping bombs?
Right?
Let's go, baby.
The 11th Amendment does not protect government officials in their individual capacities. Plaintiff has already demonstrated through her independent Rule 26F report that the individual defendants acted under color of state law and violated clearly established statutory and constitutional rights. The report documents direct evidence of discriminatory motive, a pattern of discriminatory conduct, and the defendant's own statements and actions, all which establish that a reasonable official would have known their conduct was unlawful. Plaintiff seeks damages against defendants in their individual capacities, which are not barred by the 11th Amendment. While 11th Amendment immunity may shield the state of Connecticut Department of Administrative Services and defendants in their official capacities for monetary damages. It does not extend to claims against defendants personally for violation of clearly established federal rights. Plaintiff's fourth amended complaint expressly pleads individual capacity claims under 42 USC and related statutes, and therefore the individual defendants remain properly before the court. This distinction is not academic. It directly connects to plaintiff's factual record of retaliation and discrimination. The same individual defendants who reassigned 62% of plaintiff's duties upon return from FMLA leave issued counseling letters and mischaracterized her protected speech. Wait a minute. Okay. FMLA
The
leave
same
issued counseling letters and mischaracterized protected speech are the ones sued in this personal capacity. Their conduct, documented in plaintiff's Fourth Amendment amended complaint and independent Rule 26 report, underscores why 11th Amendment immunity does not apply here. In early to mid 2023, upon defendant Fingiles onboarding, plaintiff was directed to order business cards identifying him as Assistant Director of Regulatory Compliance. However, the DAS organizational chart contemporary
contemporaneously,
yeah, listed his title
contemporaneously,
contemporaneously listed his title as Directional Project Manager. This discrepancy,
durational project manager.
what would I say? What did it say?
Okay, hold. In early
Durational
mid
project manager.
2023,
All right.
yeah, let's read that again so the audience gets it. In early to mid 2023, upon defendant Zavinglis, you could say defendant Z's since you can't pronounce his name.
Okay.
In mid 2023, upon defendant Z's onboarding, plaintiff was directed to order business cards identifying him as Assistant Director of Regulatory Compliance. However, the DAS organizational chart contemporaneously listed his title as Durational Project Manager. So you gave him a fake title to overt power over me.
This
Durational project manager is somebody who comes on temporarily to do project work, but they gave him fake business cards, a fake title, Assistant Director of Regulatory Compliance. That's not what the org chart say. The org chart is the official title of state employees.
Oh,
You understand that?
yeah, so his official
he's a
title is Durational
title,
Project Manager. So he was placed there. Okay.
correct.
Okay.
But the business cards don't match his title. That's on the state
Right.
org chart. That's the official titles of state employees. Otherwise, the state's lying to the public. He's a durational project manager. And those are temporary jobs to do
Right.
project work. But in order to overt power over someone who's performing statutory functions, you got to give them a fake title. You get it?
Yeah, I got it.
However, the DAS organizational chart contemporaneously listed his title as Durational Project Manager. Those are temporary jobs. This discrepancy reflects deliberate title manipulation designed to obscure supervisory authority and facilitate the reassignment of plaintiff's duties. So basically saying, in order for him to do that, we got to give him a fake title so he could do this. Because under durational project manager, he can't do what he's doing to her. Under Connecticut general statutes, such conduct constitute a corrupt practice as it involves false representation and collusion in state employment appointments. The use of conflicting titles to mislead internal and external stakeholders, particularly in the context of retaliatory reassignment following protected activity, supports individual liability under 1983 and defeats any claim to qualified immunity. Bomb drop.
Wow.
Now you see this shit? Crazy. I told you. Now you could go with the plaintiff. There you go. There
Okay.
you go. I do my bomb drop.
All right. Plaintiff was hired by DAS in December 2016 as a secretary to informally reclassified to administrative assistant in 2017 to perform core functions for the Codes and Standards Committee and the Codes Amendment Subcommittee. These functions, including coordinating hearings, preparing agendas and minutes, and issuing final decisions under the guidance of DAS Staff Council, constituted 62% of plaintiff's core duties pursuant to Connecticut General Statute sections. DAS is authorized to employ assistance necessary to conduct the committee's business. Defendants Hobbs, April 2024 misrepresentation of this statute, which falsely claims that the committee has never had its own administrative staff, directly contradicts both the statutory language and the plaintiff's appointment history. This misstatement was not a neutral clarification, but a deliberate attempt to strip plaintiff of her statutory authority and reassign protected duties to favored comparators, supporting claims of retaliation and pretext. Plaintiff's official title is accurately reflected in DAS organizational charts and confirmed by payroll records, which list her position as administrative assistant within the Office of Regulatory Compliance. These records further corroborate plaintiff's statutory alignment and undermine defendant's immunity and pretext arguments. Defendant Hobbs,
What
April
page are
20.
you on?
I'm on page 4.
Okay. I'm sorry. Go ahead.
I'm at the end of page 4. I'm like the last 2 sentences.
Okay.
Defendant Hobbs, April 2024 email mischaracterized Connecticut General Statute, Section 29 through 251 by asserting that the Codes and Standards Committee has never had its own administrative staff and that plaintiff therefore reports only to DAS managers. This statement is demonstrably false. The statute expressly authorizes DAS to employ assistants to support the committee and the state building inspector in enforcement. Plaintiff was hired under the authority to serve the committee. Hobbs' misrepresentation of statutory language was not a neutral clarification, but a deliberate. Maybe I did. Maybe I'm on 5. Okay. To strip plaintiffs of her statutory duties, reassign them to favorable comparators, and justify retaliatory exclusion. Such conduct indicates personal involvement, negates 11th Amendment immunity, and provides evidence of retaliatory pretext. D'Alessandro versus City of New York affirms that individual defendants may be liable under Section 1983 when acting under color of state law and violating clearly established rights. The right at issue, freedom from retaliation, discrimination, and interference with protected leave, were clearly established at the time of defendant's conduct. See Hope versus Pelzer. Officials can still be on notice that their conduct violates established law even in novel factual circumstances. Accordingly, defendant's immunity argument fails, and plaintiff's individual capacity and prospective relief claims remain properly before the court. Defendant's name Defendants named in the Fourth Amendment complaint are State of Connecticut Department of Administrative Services, DAS, Teresa Judge, HR business partner, Darren Hobbs, Deputy Commissioner and Director of Regulatory Compliance, Ashley Dempsey, HR Generalist, Peter Z, Assistant Director of Regulatory Compliance, Amaris Vasquez, State Building Inspector, Ashley Burke, HR Specialist, EEO Unit. Jordan Kubik, HR Specialist, EEO Unit. Michael Fushi, Construction Services Building Official Supervisor. Each named defendant personally participated in adverse actions against the plaintiff as summarized below. This individual conduct demonstrates why 11th Amendment immunity does not apply to the claims pled in their personal capacities. Defendant involvement and personal liability. Teresa Judge, HR business partner. 3, role senior HR official at DAS, conduct directed changes to plaintiff's duties, minimize concern in HR communication, told plaintiff to adjust to management treatment, and enforce cultural training recommendation. Impact shows direct supervisory involvement in adverse actions tying HR leadership to retaliation and discrimination, strengthens 11th Amendment individual capacity liability and Title VII claims.
Hang on right there. Hang on right there. I want to share something. Can you see this on the screen? I can't tell if you could see this on the screen.
Yes.
What am I showing?
It's an email.
Okay, cool. So remember, Mr. Hobbs said that it doesn't apply to me. It's not true, and blah blah blah.
Mm-hmm.
That I'm not doing statutory functions or whatever, and they're not my
Right.
role, whatever. Okay, this is an email from 2017. All right, so start from the bottom. Can you
Oh,
read? Can you see it from the bottom right here on the screen? See where it says, "This is the former uh, director of regulatory compliance's email. His name was Mr. Cassidy. Clarification received, and it states the following. You see this?
okay. Clarification received from Mr. Cassidy, and it states the following. The position she fills is the secretary to an OSBI under Tierney. That is where
Yep.
most of her duties, okay, there you go. That's where most of her duties are assigned. Code and standards, appeals and modification. This was all work Joanne was doing before she retired, which were duties performed by an AA and secretary to prior to the AA's retirement 4 to 5 years ago. The only roles she performs for my AA position are my scheduling phones, etc. My scheduling phones, etc. The AA under me in the organizational chart now was shared between Barkin and I. We had adjoining offices with an anti room in the old building.
Now, look at the lady in HR who agrees to my duties. Here we go. Read it. And they still gave me a lower title, even though I'm performing he literally told them that I was performing statutory functions, correct?
Right.
So now look what the human resource lady said. But they
Okay, I
gave
only
me a lower title. Remember, I told you it's more like nigger, you're gonna do the work, but you're not getting the title and the pay. But go ahead, read it. Hi, Elena.
I don't see hi Elena. I don't see hi
It's on the
Elena.
top. I didn't stop the share screen, did I?
No. Okay, there we go. My computer is kind of okay. So it says, hi Elena. It says, I reviewed the supplemental information that you submitted and do agree that Ms. Giles Smith is performing at the level of the administrative assistant. I need to be sure that she meets the ENT and core is down this
Is
afternoon.
down.
Okay, and core is down this afternoon. If she meets the ENT, I am supportive of promotion by reclassification to the AA.
Now they agree. I'm performing statutory functions. But it's still that same old thing, girl. You nigger. You could get the you could get the
You could do the
you
work.
could do the work, but you ain't getting the title and you ain't getting the pay. But I just showed how HR was involved in this. If I'm white, okay, now I could get the title. I could get the title if I'm white. But because I'm a nigga, you could do the work and wait, you didn't peep that I'm doing two people's
Yeah.
jobs, right?
Yeah.
The
Yep.
AA and the Sec 2.
Right.
Oh, you a bad nigga. You could do both of those? Ha. Yeah, you could do the work, but you ain't getting the title and you
I'm
ain't
not
getting the
going to pay
pay.
you.
I'm just saying how I feel and how I felt. And that was in 2017. I've been doing the same job all the way up until Peter and Omaris ass came in 2023 with no issues. And guess what? The commissioner, Darren Hobbs, he fucking trained me. How about that? Things we forget about. I can't fuck up with the commissioner that trained me because back then he was a technical service assistant or something like that. I can't remember. I don't know. But all this is noted in here. You're gonna read it. But I'm showing personal liability right here is what you're reading. You just finished judge. But y'all got it. Thanks for the fire, y'all. This is a hot fucking mess. It's that same thing that I'm talking about, y'all. Nigger, you are educated, you could do the work, but you're not getting the title and the pay. But the white people come in and they give them hire that one title and give them a fake title.
Which
see
is
that?
yeah, which probably they were getting paid more than, especially like the guy who was
Oh, of course.
yeah.
And they're all former building officials from local municipalities. I worked with them while they were in the municipalities before they came to the state and got jobs in 2023 and 2022.
Wow.
So you're telling me a building official is more experienced than me with my educational background, and I've been working in state
Doing it for
government
all
since
this year.
2001.
Yeah.
You got it,
And
girl.
then they
Here's
come
a little
in
human
and then
resource generalist.
okay. So Ashley Dempsey, HR generalist, right? That's where I'm at.
Yeah.
3 role, DAS, HR generalist, work directly with Teresa Judge, conduct, email plaintiff the link to take the culture course after Burke's bias EEO report, participated in HR communications enforcing cultural training recommendations and returned from EMLA leave in 2025 without adverse changes while being promoted from HR generalist to HR generalist 3. Impact: direct involvement in retaliatory enforcement of bias EEO recommendations. Comparator evidence: treated more favorably after FMLA leave, while plaintiff lost 62% of duties. Strengthens Title 7, ADEA. Let me pull this up. Disparate treatment and First Amendment retaliation claims. Ashley Burke, HR Specialist, EEO Unit, role, EEO Investigator at DAS, conduct, authored April 21st report recommending diversity training based on plaintiff's YouTube channel targeting plaintiff's cultural commentary on problematic
As
as problematic. Sorry. Impact constitutes viewpoint discrimination and retaliation for protective speech. Anchors Section 1983 First Amendment retaliation claim demonstrates biased investigation as adverse action. Jordan Kubik, HR Specialist EEO Unit Role EEO Investigator as DAS Conduct issued December 23rd, 2024 report characterizing plaintiff speech and omitted exculpatory evidence from investigation. Impact shows reckless disregard for truth and collusion with management. Strengthens Section 1983 First Amendment retaliation claims. Demonstrates discriminatory motive and pretext. Omaris Vasquez, State Building Inspector.
Omaris. Omaris.
Omaris. Oh, her name is
Omaris.
Omaris. Okay. Omaris Vasquez, State Building Inspector. Role, Supervisor in DAS Regulatory Compliance. Conduct, mischaracterized plaintiff's role in January 2024 emails, reassigned civil government responsibility to a younger comparator, harassed plaintiff in hearings, and maintained her own YouTube channel and nonprofit activities without discipline. Impact, comparator evidence Vasquez was treated more favorably despite similar conduct. Demonstrates discriminatory motive and retaliation, supports hostile work environment and disparate treatment claims.
So hold right there. She got a YouTube channel.
And she's complaining
And
about
I had
yours.
all
Okay.
this is in the exhibits. I screenshotted her YouTube channel. And as state employees, you're not supposed to and get YouTube subscribers from state government site with your nonprofit organization. And you're not supposed to be in a state office, okay,
Mm-hmm.
at a meeting for your nonprofit using state equipment. I got the screenshot. That's at an exhibit on the docket using state equipment. But you're fucking with me, and I'm on my own personal time in my own real company
Mm-hmm.
doing my business. But she's not being disciplined. And
Wow.
all that screenshot, all the exhibits I showed you, all this stuff is already on the docket. You fucking
Okay.
with me about my channel, but not her about hers. Something's wrong with this picture here. So I was able to screenshot that shit and downloaded the video. Saying, I'm a state building inspector. You're not supposed to do that on YouTube, on your personal
On your personal
nonprofit
capacity.
channel.
Right.
I don't say shit about myself. Yeah, I say I work for the state, but that's it.
Right.
It ain't nothing to fucking brag about. But that's stuff that's against state policy. Why am I being fucked with? But go ahead. You want me to
Okay.
read a
So,
little bit?
if you would like.
Michael Fushi, construction service supervisor, role. These are people she dragged in with her, and I knew Mike before she did. I got him set up for the job and every fucking thing. And then guess what he do to turn around? I'm like, he came from out of the woodwork. Supervisor in DAS construction service conduct. He submitted a false sworn affidavit mischaracterizing plaintiff's attire. He said, I came into a meeting with a fucking nightgown on. And they screenshot it. It's a fucking blouse, y'all. And I wore it with my jeans with heels. Same blouse. So that's when CHRO really flipped the script. They was like, what the fuck? Because it's a blouse. And he said I had on a nightgown. And I, in my response to CHRO, I was like, was he fantasizing that I was in a nightgown? but this is a blouse. So I stood up and took a picture of me in it, in my blouse and jeans and my heels. How the fuck is this a nightgown? Same blouse. Impact, direct evidence of discriminatory motive and retaliation. Supervisor's Title VII hostile environment claim constitute extreme and outrageous conduct for intentional infliction of emotional distress claim. Number one, you signed a false affidavit. That's right there is grounds, bad grounds. You said I wore a nightgown to a meeting. The fuck? Anyway, Peter, Assistant Director of Regulatory Compliance, even though the organizational chart, and that's in Exhibit 2, says that he's a durational project manager. Senior role, senior DAS official with supervisor authority, conduct, issue counseling letter against me, manipulated titles, durational project manager versus assistant director to obscure authority, and participated in supervisory override of plaintiff's duty. Impacts shows direct supervisory control and manipulation, which strengthens the Title VII and 1983 liability, demonstrates deliberate structural moves to strip plaintiff's role. You got it right here. Hobbs.
So, usually in an
Mhm.
organizational a chart, you have like the people directly above you. Does one of those
Mhm.
roles say, was it durational project manager as a
Yeah, on the
supervisor?
org chart.
Okay.
No, they don't have
Okay.
supervisory authority in their job class. That's why I put their job descriptions in is one of the exhibit. It shows that a durational project has no supervisor authority. They don't. They're temporary employees hired to do little projects. But when he came in, they gave him a fake title to overt power over me because I'm performing statutory functions, and a little durational project manager does not
Can't.
have the authority
Right.
or supervisory. There's no supervisory even mentioned in their job descriptions. So
Wow.
that's in the as an exhibit. His job description is an exhibit and uploaded on the docket.
Wow. That's huge,
So
actually.
that
That's
all
huge.
those exhibits, yeah, it's huge. All those exhibits will is already there for when we go to the discovery. She ain't even got to look at none of that. But if she looks at it and considers it in her ruling, it will automatically revert my case to summary judgment.
So he didn't even
And
have the
that would
authority
be
to
because
add or take away any of your duties.
nope.
Okay. All right. We've established this. Darren
I can pull
Hobbs.
up his job description.
Darren
But because
Hobbs,
they gave him that
uh,
fake title.
it
But
appeared
all
as
this,
if he had
yeah,
authority. Yeah.
correct.
Okay, so Darren Hobbs, Deputy Commissioner, Director of Regulatory Compliance, role, Senior DAS Executive, conduct, reassign plaintiffs' contract management duties to comparator Saucy, and maintain dual titles Deputy Commissioner and Director of Regulatory Compliance. To preserve control, impact shows top level involvement in adverse actions, demonstrates discriminatory intent and accountability, strengthens Title VII, disparate treatment and
Disp-
um, retaliation claims.
claim.
Plaintiff protected plaintiff's protective activity is not speculative. It is documented by corporate filings and professional recognition. Plaintiff is the president and CEO of Copper Color Chronicles Incorporated and the Waya Nation Incorporated, both incorporated in Florida, and has been a recognized YouTube partner since 2018, operating a monetized channel and related websites. These enterprises are lawful, professional, and protected under the First Amendment. Yet defendants targeted plaintiffs' channel and business ventures as problematic, while defendant Amaris Vasquez
Mhm.
maintained her own YouTube channel and social media presence without discipline. This disparate treatment underscores comparator evidence. Plaintiffs' legitimate businesses and speech were singled out for retaliatory investigations, while similarly situated employees engaged in comparable online activity were treated more favorably. Plaintiff's fourth amended complaint alleges First Amendment retaliation under 42 USC 1983. Defendants Burke and Kubik colluded with management to suppress plaintiff's cultural commentary and mischaracterized her off duty speech on her YouTube channel and website. Burke's April 2024 report recommended diversity training based on plaintiff's viewpoint, constituting viewpoint discrimination. Plaintiff is a YouTube partner. There's an Exhibit O, President and CEO of Copper Colored Chronicles Incorporated and the Waya Nation Incorporated, and owner of 2 websites. These independent enterprises are protected First Amendment activity. Government employees may not punish employees for off duty speech unless it disrupts workplace efficiency. And defendants allege no such disruption. Pickering versus Board of Education. Rankin versus McPherson. At the pleading stage, these allegations are sufficient to state a First Amendment retaliation claim under Section 1983, Dolan versus Connolly. Amaris Vasquez YouTube channel. Defendant Vasquez maintained her own YouTube channel and social media presence while employed by DAS. Yet plaintiff's monetized YouTube partner business was singled out for retaliatory investigation and mischaracterization. This disparate treatment underscores comparator evidence. Vasquez was permitted to operate her channel without discipline, while plaintiff's channel was targeted as problematic and used to justify adverse actions. The inconsistency demonstrates discriminatory motive and retaliation, as similarly situated employees engaged in comparable online activity were treated more favorably. Plaintiff has already proven clearly established right, violation of rights. The 26F report details interference with FMLA reinstatement. Facts 26 through 20 deny retaliation for protective speech and disparate treatment based on race and age. Direct evidence. Defendants' own affidavits and counseling letters. Defendants' own affidavits and counseling letters mischaracterize plaintiff's attire and speech, showing discriminatory motives. Patterns of discrimination. The report documents repeated reassignment of duties, exclusion from hearings, and biased investigations. Established law. Plaintiff cites controlling precedent. Potenza, Pickering, Rankin, Mudrow, Appleton, showing that these rights were clearly established. Obvious violation, the 62% reduction in duties upon return from FMLA leave is so egregious that no reasonable official could believe it lawful. 62% reduction is huge.
Yes, it come very
Okay.
huge. And I'm gonna pull up the proof for that too.
Plaintiff has already proven a reasonable official would have known. Knowledge. Defendant's DAS job description noted on their business cards and in-state policy manuals expressly require compliance with federal and state employment laws. Recklessness. Kubik's December 23, 2024 investigation report omitted plaintiff's exculpatory evidence, showing reckless disregard for the truth. Bad advice. Defendant's reliance on biased internal reports was unreasonably, especially given their access to plaintiff's documented proof. Institutional policies, DAS, EEO, and HR policies put defendants on notice that retaliation and discrimination were unlawful and they disregarded them. Knowledge. Defendants' DAS job descriptions noted on their business cards and in state policy manuals expressly require compliance with federal and state employment laws. Title inconsistencies. Exhibit J, the job description and organizational chart show that defendant Peter Z was listed as durational project manager on the organizational chart. Yes, his official DAS business card identifies him as assistant director of regulatory compliance. This discrepancy demonstrates defendants' manipulation of titles to obscure supervisory authority while exercising control over plaintiffs' reassigned duties, underscoring that reasonable officials in these roles were on notice of their compliance obligation. Dual titles and authority. Exhibit J and Exhibit K confirmed that defendant Darren Hobbs was appointed deputy commissioner, while simultaneously listed as director of regulatory compliance on the organizational chart. Hold on. The other guy is also director of regulatory compliance.
Okay, so let me show you.
Okay.
Before before Peter was placed in the role that he's in, Darren Hobbs was my boss.
Okay.
He was the director of regulatory compliance.
Okay.
And what happened when the new administration came in, they appointed him as deputy commissioner. So he couldn't do both roles because they were
Right.
overwhelming. So they assigned Peter as my supervisor and he's durational project manager.
Okay. And so he was fulfilling
Okay.
this other guy's role.
So what happens, right? Let me explain what happens. Darren
Okay.
goes and accepts position that he's appointed as a deputy commissioner. So what
Okay.
happens? His original job, that deputy commissioner job only stays in effect until a new administration come in, and they might say, "Oh, I don't want him working for me." So he goes back to his old job.
Okay.
So Peter's put there as a fill-in, but it was under the title of durational project manager. And that's what's on the org chart right now to this day. So he got a fake title to overt power over me.
I get it. I see it. I see
So-
it. I see it.
So yeah, if the new governor comes in and they might say, "Oh, we don't want him as our deputy commissioner," and they'll appoint somebody else, so he gets to go back to his old job, and Peter's gone because his job is really temporary, not a permanent job. Durational project manager. Okay.
All right, I got it. On the organization. Okay, so his appointment record business card, his appointment record business card reflects deputy commissioner. This dual designation confirms Hobbs' ongoing supervisory authority over regulatory functions and plaintiff's duties, and further shows that defendants maintain overlapping titles to preserve control and evade accountability, despite clearly established compliance responsibilities. Exhibit G through M in January 2024, email exchange, and September 2023 appointment letter. These exhibits collectively demonstrate exclusion, misrepresentation, reassignment of duties, and improper supervisory override. The January 23rd to 24th emails show defendant Vasquez mischaracterizing plaintiff's role, reassigning civic government responsibilities to a younger employee, and declaring that plaintiff would transition from one-on-ones with Peter to me, quote unquote. The September 2023 HR appointment letter, however, formally designates Peter Z as plaintiff supervisor. Together, These documents establish an undisputed factual conflict. Defendants attempted to override an official supervisory assignment while simultaneously diminishing plaintiff's duties. This contradiction evidence retaliation, discriminatory motive, and contributes to hostile work environment.
Now
Plaintiff,
let's stop there
okay.
for a second. Hold up, because I want to show you the duties 60%. All right. We have to fill out a form when we classified. This was back in 2017 when I got the reclassification. Remember, remember, you have to give a breakdown of the percentage of your work and what you're doing. And remember, Mr. Hobbs said she's not doing statutory functions and blah 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 blah. But here's the duties questionnaire percentage breakdown of my job. What does it say in the far left hand corner
I
as a
still
codes
see
and standards?
I still see the what I'm reading on the screen.
Wait a minute. I thought this was showing. Wait a minute. It should be showing. There it is. It's up on the screen.
Okay, it's
I
on the
see
screen
it. What are you
now.
looking at?
Okay, I see it
Okay,
now.
so what does it say in the far hand left hand corner? How much percentage of codes and standards committee appeals functions do I do?
Where the far left hand corner?
Far
State
left.
codes. State building code.
Look to the far left of that. You see a
I don't
percentage up
I
there?
don't see yeah, I don't see it.
All right, you see state codes and standards, right?
Yes.
Now look to the left. Look right directly to the left. You don't see a number there?
Oh. I do see a number. It says
I'm gonna beat you
62%.
down.
All right.
That that's basically my fucking job. And all of it is based in statutory functions. Look on the left. On behalf of the Office of State Building Sector, this is the portion of the State Building Inspector's office as admin that I did for managing the whole entire. I manage their business, their operational business, the committee, and I handled the appeals function. What does that say? Just read the red part.
Oh my gosh, I'm not going to be able to see that. My
Oh,
computer
let
is
me let me blow it up. What does that say?
Okay, it says on behalf of the Office of State Building Inspector, independently coordinate, manage, and oversee the State Codes and Standards Committee, appeals functions, and according to Chapter 541 of the CGS.
Connecticut General Statutes.
Mhm.
And I'm not performing statutory functions
Mm.
on behalf of the Office of State Buildings to independently coordinate, manage, and
And
oversee the State
oversee.
Codes and Standards Committee appeal functions according to Chapter 541 of the Connecticut General Statutes. And it breaks down what I do. Monitor statutory appeal periods according to Connecticut General Statutes 29. I'm doing statutory fucking work.
Okay,
Statutory work and clerical work is two different things. I'm
so
not a clerical
so
worker, but
even in
huh?
their motion to dismiss, they're still diminishing your role.
I
They're
can't
still
talk
saying
about what's happening forward in 2026.
no. I'm just saying. You're saying right here that it shows that you have statute functions, but so what you're saying I did. So even in their motion to dismiss, they're still diminishing your responsibilities, your role in the company. That's what I'm saying.
Yes, correct. I've been doing this since 2016. And see, when I went out in 2024 on FMLA for them 6 weeks,
Mhm.
because I saw what they was doing to me, and my doctor took me out on FMLA. And when I came back a month later, they took my whole fucking job and moved it to the legal unit when I was already working with the legal unit for this very same thing. They swiped my duties away from me. 62% of my job. That's adverse action.
Right.
That's against FMLA. My job is supposed to be protected. But you
Right.
swiped it and gave it to the legal unit. That is violation of FMLA rights, is what I'm saying.
Right.
That was a violation of my FMLA rights. And he lied and said I was not performing statutory functions. We're reading statutory functions all through this fucking document. And let's get here. Look at this. Let me know when you see the next change. Do you see this right here? This was back in 2017. You see these signatures? Position authorization requests. Signed by the manager, division director, the goddamn commissioner, may she rest in peace, all agree that I'm doing statutory functions. But even though these people agreed, this is the commissioner, may she rest in peace. She passed away. But they all signed this document and agreed that I'm performing statutory functions. And like I said, yes, you're performing statutory functions, little nigger, but you're not getting the fucking title and you're not getting the pay. My title is supposed to be manager of regulatory compliance.
Oh,
But
wow.
because you're a little educated black nigger, you're not getting that title. But you do the work. But we ain't giving you the fucking title. You nigger, you will not get this.
And so they kept you
You will
as
get
administrative
a low
assistant.
level title.
Yeah.
Correct. Since my date of hire, that is fucking way back.
Years ago.
And I just held my lip, kept my tongue silent because I knew I had to take care of my grandbabies, my twins, because they was just born at this time. They was born in 2015. And I said, you know what? I'm just going to keep these are not the people who did it to me. It was HR. Instead of giving me my title that's on my timesheet, they classified me as a clerical person when I'm not supposed to be. I'm doing manager work. It says it right there. And they agreed and signed. All these division heads. So, yeah. So, like I say, honey, you this is the shit that we go to as a people. As a people. And to sit there with a blank face and say, we did no harm. This is every fucking thing in the world. You stop my career trajectory. I could do the legal work, but I can't fucking have to pay like the white people get. No, bitch, you ain't getting nothing. And they don't understand how that can trigger anxiety and depression and panic attacks because you've been doing this before these people that took it away from you came, and you've been performing this job professionally and never been looked at as somebody considered to have a rightful title. But you give them fake titles to overpower. This is horrible. This is why the motion to dismiss ruling is taking so long. All those exhibits are on the docket. So I'm ready for fucking discovery. But it is what it is. But I'm strong and I'm still hanging in there and I'm fucking alive. Where did you start at, honey?
Okay, so I stopped at plaintiff has already met her burden. I think.
There you go.
All right.
Yeah, you got
All
it.
right. Okay, so
I'll blow it up more. Is that good enough? Oh, you're reading from your paper.
yeah,
All
yeah,
right.
good. Preponderance of evidence. The 26F report consolidates documentary proof, emails, evaluations, affidavits, comparator promotions, and CHRO responses, showing violations are more likely true than not. Burden satisfied. Plaintiff has carried her burden by presenting facts, not mere conclusions. qualified immunity defeated. Because the rights at issue were clearly established and defendant's conduct was egregious, qualified immunity does not apply. Accordingly, defendant's 11th Amendment immunity argument fails, and plaintiff's individual capacity and prospective relief claims remain properly before the court. Defendant involvement and personal liability. Defendant's name in the Fourth Amendment complaint include the State of Connecticut Department of Administrative Services, DAS, and individual officials. While DAS is immune from damages under the 11th Amendment, the individual defendants are personally liable for their conduct. See Case Law Index Table. Mapping plaintiff's claims for prospective injunctive relief and individual capacity liability to controlling precedent. Title 7 ADA and ADEA claims are properly exhausted and pled. Plaintiff filed timely charges with CHRO and EEOC. Exhaustion is satisfied. Defendants argue no adverse action, but plaintiff alleges reassignment of 62% of duties upon return from FMLA leave, downgraded performance evaluations, retaliatory investigations, and disciplinary letters based on false accusations. This email chain documents plaintiff's formal request for a reasonable accommodation under the Americans with Disability Act, citing generalized anxiety disorder and fear of COVID exposure due to multiple personal losses. Plaintiff requested full-time telecommuting, explaining that her duties were fully remote compatible and that she was already equipped with a home office setup. DSHR responded with blank ADA form and intake questions confirming that the request was accepted for processing. This exchange supports plaintiff's ADA discrimination and retaliation claims by establishing her protective status. Her good faith request for accommodation and the agency's acknowledgement of the request. It also undermines any claim that plaintiff failed to engage in the interactive process. These are adverse actions under Burlington North and Santa Fe Railway versus White. Comparator evidence shows White and male employees returned from FMLA leave without adverse changes. Supporting discrimination and retaliation claims. Muldrow versus City of St. Louis. Plaintiff's protective status under the ADA and Title VII is well documented. Between October 24th and February 25th, plaintiffs submitted multiple medical certificates, FMLA, eligibility notices, and fitness for duty forms, confirming severe anxiety, depression, and panic attacks directly caused by workplace retaliation. Human Resources approved plaintiff's FMLA leave through November 19, 2024, and received a signed intent to return to work. Upon return, plaintiff's physician certified that she could perform her duties only if permitted to telework full-time, a restriction formally acknowledged by DAS. Plaintiff then filed ADA accommodation requests in November 2024, which were granted in February 2025, authorizing 100% teleworking through February 2026. These exhibits collectively establish plaintiff's protective class status, the agency's knowledge of her condition, and the legal obligation to restore her to an equivalent position without retaliation or reduction in duties. The 26F report documents undisputed facts. Plaintiffs returned from approved FMLA leave on November 19, 2024, and approximately 62% of her duties were reassigned. This is a textbook adverse reaction under Burlington Northern. The report also identifies comparators: Hart, Saucy Dempsey, who were treated more favorably, supporting disparate treatment claims. Race and age discrimination, hostile environment expanded. Plaintiff alleges that defendants engaged in a pattern of discrimination and retaliation designed to diminish her role and force her into retirement. Defendants cannot dispute plaintiff's protective status. DASHR itself corrected plaintiff's race as American Indian. Despite this acknowledgement, plaintiff was treated less favorably than white comparators, including Hart and Saucy, who absorbed plaintiff's duties and received promotions. As documented in plaintiff's independent Rule 26F report, upon plaintiff's return from FMLA leave on November 19, 2024, approximately 62% of her core job functions were reassigned to other employees, including younger and white comparators. One such comparator, Danielle Hart, a 27-year-old white female secretary 2, was promoted into the DAS boiler unit, and under defendant Vasquez as a licensed application analysis, a position with a higher salary trajectory than plaintiffs. As detailed in Section 1, Defendant Hobbs misrepresented statutory authority to justify stripping plaintiff's duties, further evidencing discriminatory reassignment and retaliatory motive under Title VII.
The
See,
same dude that trained me to do statutory functions is the same one that stripped it from me. Tell me I ain't doing them. And here's the statute. I put it right there. Here's the statute. See it? Let me move this in the middle.
I see it.
I put the motherfucking statute. Let me go down a little bit. Now, read the last line. This is just tells you statutory codes and standards committee's duties membership. All right. Now, the only important sentence here is this one. This last sentence right here. Oop, what are we doing here? Look at right here. The committee. Oh, shit. The committee, I'll read it. I'll make it big because the audience can't see it. This is the statute that I worked under for years before there was even a damn Peter and Amaris. And it clearly says the committee may, within the limits of appropriations, provide, therefore, employ such assistance as may be necessary to conduct its business. Hello? He said that I don't. But yeah, I was hired to do the fucking job.
All
You see
right.
that? You see that?
Yeah, I see it.
That's my job. A hot
Wow.
mess. You got it, hun.
All right. Okay, so we need to see organizational charts and comparator documents, which confirm Daniel Hart's promotion from Secretary 2 to Licensed Application Analyst in July, August 2025, while plaintiff's duties were reassigned and reduced. This promotion was
Yeah, they
not
hurry up
in.
and scooped her over there so that they could have dodged being discriminatory with her because the plan was to force me to retire so she could take my job. But that didn't happen. So they quickly removed her when I filed this complaint. But
Mm,
that don't erase what the fuck you it don't erase what the fuck you did. And I'm standing on it. I'm standing on my shit. And nothing. I don't care if they fix it right now. It don't erase what the fuck you already did to me. Let's go.
This promotion was not a neutral career move. It was a part of defendant's ongoing scheme to groom Hart as plaintiff's replacement, while simultaneously harassing and retaliating against plaintiff to pressure her into retirement. Plaintiff was
I'm still
responsible.
here.
Right. Right. And then it's really kind of telling that they went and moved her right up under Vasquez in a different role, but she's still, okay. Anyways, this
Yeah,
promotion
real
was,
fucked up.
yeah,
The judge see this. They ain't stupid. I know them clerks in their office is probably, if they don't smoke cigarettes, they probably started smoking them. But go ahead, you got it.
wow. So this promotion was not a neutral career move. It was part of defendant's ongoing scheme to groom Hart as plaintiff's replacement, while simultaneously harassing and retaliating against plaintiff to pressure her into retirement. Plaintiff was responsible for handling the contract for office equipment, including copy machines, toners, and supplies for the unit. In 2025, defendant Darren Hobbs reassigned.
Oh, I don't know what page you on.
Okay, so I am on page 15.
Oh, okay. So I'm on the right page. Sorry.
Oh, no problem. Okay, so plaintiff was responsible for handling the contract for office equipment, including copy machines, toners, and supplies for the unit. In 2025, defendant Darren Hobbs reassigned this responsibility to white female employee Saucy, materially reduced plaintiff's role and authority. This reassignment, combined with the 62% reduction in duties upon plaintiff's return from FMLA leave, demonstrates discriminatory intent and disparate treatment. See Exhibit G through M, which is comparator and duty reassignment proof. As detailed in Section 1, defendant Hobbs misrepresented statutory authority to justify stripping plaintiff's duties, further evidencing discriminatory reassignment and retaliatory motives under Title VII. This email exchange demonstrates the plaintiff maintained 8 years of positive, respectful relationships with all 21 codes and standards committee members without a single incident of hostility until defendant Vasquez interference. Plaintiff's contemporary why this word just gets me contemporaneous communication to HR documents her shock at receiving for the first time a critical response from committee member Harwood, a departure from the committee's historically humble and collegial treatment of her. Plaintiff respectfully notes that Vasquez sought to turn committee members against her as retaliation and that Harwood's unusual commentary was unprecedented in her tenure. This evidence supports plaintiff's Title VII hostile environment claim and her IIED claim section, by showing retaliatory manipulation of trusted colleagues to isolate and undermine her role. Plaintiff did not retire, but the damage was already done. Her duties were stripped, her career trajectory was disrupted, and her workplace role was diminished. These facts demonstrate disparate treatment based on race and age, as younger white employees were advanced and supported, while plaintiff, a brown-skinned American Indian woman over 40, was excluded, reassigned, and targeted for removal. Courts recognize that discriminatory grooming of comparators and stripping duties can establish both Title VII disparate treatment and ADA age bias. Mudrow versus City of St. Louis. The pattern of harassment, exclusion from hearings, humiliating investigations, and retaliatory reassignment also establishes a hostile work environment. Harris versus Forklift Systems. Title manipulation and evidencing control. The documentary record shows defendants used overlapping and inconsistent titles to facilitate the reassignment of plaintiff's core functions. Z appears as durational project manager on the organizational chart, but holds assistant director of regulatory compliance on his DAS business card. Okay, hold on. I got to pull up the.
Yep.
All right. While Hobbs is both deputy commissioner and listed as director of regulatory compliance on the organizational chart, these inconsistencies align with the reassignment of codes amendment subcommittee work to Hart and the 62% post FMLA duty reduction, evidencing deliberate structural moves to strip plaintiff's role and elevate younger white comparator. Defendant's manipulation of titles and reassignment of plaintiff's duties constitutes a corrupt practice under Connecticut General Statute, Section 5 through 226, which prohibits false representation and collusion in the state employment appointments. By mischaracterizing plaintiff's administrative assistant role, directing her to order business cards with a fabricated title of Assistant Director Regulatory Compliance, and simultaneously appearing on the DNS organizational chart as durational project manager, defendants engaged in deliberate misrepresentation designed to obscure accountability and facilitate retaliatory reassignment. Such conduct was not a neutral personnel decision, but a calculated scheme to strip plaintiffs of statutory authority and promote favored comparators outside of merit-based procedures. Because sections 5 through 226 expressly forbid these practices, and because no reasonable officials could believe that falsifying titles and colluding to reassign protective duties was lawful, 11th Amendment immunity does not apply and qualified immunity must be denied. Defendant
Coin.
yeah. Defendant
Hot mess, right?
right. Wow. Defendant conduct relevant to Title 7, 88, and 88 claims. Defendants engage in a coordinated pattern of discrimination and retaliation designed to diminish plaintiff's role and force her into retirement. Their major conduct is summarized below, with all additional actions detailed through this opposition. See case law title index. And
Yeah, she got an index.
okay. So plaintiffs states a claim under Section 1983. Plaintiff alleges retaliation for protective speech, YouTube channel, internal EEO complaints, and denial of equal protection. Individual defendants acted under color of state law. Qualified immunity is not appropriate at the pleading stage where facts show violation of clearly established rights. Dolan versus Connolly. Courts deny dismissal where factual disputes exist. Littlejohn versus City of New York. Plaintiff's 26F report details how defendants Burke and Kubik mischaracterized plaintiff's off-duty speech and cultural identity using her YouTube channel as a basis for discipline. This viewpoint discrimination is documented in the report and supports her Section 1983 First Amendment claim. Plaintiff states a claim under the First Amendment EEO bias and collusion. Defendant's retaliatory investigation into plaintiff's cultural speech was not only viewpoint discrimination, but also racially biased. DASHR's correction of plaintiff's race to American Indian confirms her protected identity, which defendants targeted through discriminatory reassignment and hostile investigations. Plaintiff's Fourth Amendment amended complaint alleges that defendants Burke and Kubik has EEO investigators colluded with management to suppress plaintiff's evidence and mischaracterized her off-duty speech. As documented in plaintiff's independent Rule 26F report, facts 18 through 20, 33 through 40, Burke's April 2024 report recommended that plaintiff be investigated for her private YouTube channel and required to complete a diversity training based on cultural commentary. These
Now
actions
hold up. They said my private YouTube channel. Yes, it is private. So why are you worried about my damn private YouTube private life? You can't do that. That's violation of my First Amendment. You're gonna investigate my private YouTube channel. It's a business. And it's private. It has nothing to do with the state of Connecticut. I'm not even incorporated in Connecticut. I work for Wire. I work for Copper Color Chronicles. I work for YouTube. I'm a partner. What does the state of Connecticut have to do with my personal job after work hours when I'm not in the scope of my employment? But you got it. First Amendment retaliation at its finest, but you got it.
Yeah, and absolutely constitutes as viewpoint discrimination. These actions constitute viewpoint discrimination and retaliation for protected speech on matters of public concern. Pickering versus Board of Education. Connick versus Myers. Plaintiffs' YouTube lectures and cultural advocacy are protected First Amendment activity. Government employers may not punish employees for off-duty speech unless it disrupts workplace efficiency. And defendants allege
Okay, stop
no
there. Unless it disrupt workplace efficiency. I'm not working when I'm on YouTube. So
right.
how is it disrupting workplace efficiency? Hello. Stop watching my fucking channel. I didn't tell nobody to subscribe to my channel. But y'all got it. Let's go. That's why I'm here today reading this so people can understand how to fight for themselves. You gotta fight back. I'm not intimidated by people. I just look at them. But go ahead, you got it, baby.
And defendants allege no such disruption. Rankin versus McPherson. The EEO unit's bias investigation, collusion with management, and retaliatory recommendation of cultural training are adverse actions that chilled plaintiff's speech and violated clearly established constitutional rights. Plaintiff has not been able to upload papers on our Copper Chronicles website for an entire year due to defendants' humiliating and embarrassing actions. This has caused a serious interruption in plaintiff's YouTube channel business and newspaper operations. The fact that docket information is publicly accessible across states has compounded the humiliation and embarrassment. At this pleading stage, these allegations are sufficient to state First Amendment retaliation claim under Section 1983 Dolan versus Cannoli. Plaintiff is a YouTube partner since 2018, the president and CEO of Waya Nation, and the owner of the Copper Color Chronicles, which is connected with her YouTube channel. All of plaintiff's private businesses are incorporated in Orlando, Florida. Plaintiff introduces comparator evidence solely to demonstrate selective enforcement and pretext. This evidence does not constitute a new claim, but supports plaintiff's existing causes of action for retaliation, discrimination. For example, um, Omaris Vasquez, while serving as president of NOMA Connecticut, maintained a YouTube channel titled I Am a State Building Inspector and conducted nonprofit meetings at her state desk using state equipment during work hours. Defendants did not investigate or discipline Vasquez despite clear violation of DAS policy, while plaintiff was singled out for protected First Amendment speech while off duty, I might add. Ashley Dempsey, a white female DASHR generalist, interacted with plaintiffs throughout 2023 and 2024 and part of 2025 while serving first as a human resource generalist 2 and later as human resource generalist 3. During this period, she worked directly with Teresa Judge in DASHR and participated in communications enforcing biased EEO recommendation. Upon returning from FMLA leave in 2025, Dempsey experienced no adverse changes to her duties and was promoted from HR Generalist 2 to HR Generalist 3. By contrast, plaintiffs returned from approved FMLA leave in November 19 to 2024 resulted to an immediate reassignment of approximately 62% of her core duties. This disparate treatment demonstrates that similarly situated employees outside plaintiff's protective class were treated more favorably, while plaintiff was penalized for exercising her statutory rights. Under McDonnell Douglas Court versus Green and Muldrow versus City of St. Louis, such comparator evidence establishes pretext and supports plaintiffs' Title 7 88 FMLA retaliation claims as of November 28, 2025. Dempsey is listed as a human resource supervisor at the Connecticut Technical Education and Career Systems, continuing her upward career trajectory without interruption or reassignment. Plaintiff makes clear that the First Amendment retaliation is tied to all those involved, as it is evident that defendants investigated her channel by their recommended actions in the conclusion of the investigation report. Plaintiff's YouTube channel has nothing to do with the state of Connecticut. Plaintiff has never stated that she represents the state of Connecticut, has never invited state employees to her channel, and has never discussed her private business with anyone at her state employment. Plaintiff has worked fully remotely from home since COVID-19 and does not have YouTube communication interactions with DAS employees, nor does she conduct any business in the state of Connecticut. McDonnell Douglas Court versus Green. Establishing burden shifting framework to employment discrimination cases. Plaintiff may show pretext by demonstrating that similarly situated employees outside the protected class were treated more favorably. Muldrow versus City of St. Louis. Holding that discriminatory transfers or reassignments, even without significant harm, can constitute actionable discrimination under Title VII, rejecting heightened harm requirement.
So basically, what they're saying here, you just have to show adverse action took place. It don't got to be tragic. It just show some harm. There's the harm. Mine is horrifying.
Accordingly, under McDonnell, Douglas, and Muldrow, plaintiff's comparative proof demonstrates pretext and supports her Title VII ADA and ADEA and Section 1983 claims, as further addressed in Section 4 and 5 below. Defendant involved in personal liability. Each named defendant personally participates in adverse action against plaintiff, as summarized below. These individualized actions form some of plaintiff's statutory and constitutional claims. Although the actions they have individually been involved in are addressed in Section 1 through 4, which reveal how they work together against plaintiff. See Case Law Index, Section 3, Table, Section 3. Mapping plaintiff's Section 1983 claims to controlling precedent on First Amendment retaliation, equal protection, and qualified immunity. FMLA and CT-FMLA claims are viable expanded. Plaintiff alleges interference with approved FMLA leave and retaliatory reassignment of duties. Upon plaintiff's return from FMLA leave on November 19, 2024, approximately 62% of her core job functions were reassigned to another administrative assistant in the legal unit. This reduction is ongoing and constitutes a clear adverse employment action.
So you
Comparator
took it from
evidence.
one admin to gave it to another, and she don't even fucking know she's doing statutory function. Girl, I'm done. Go ahead on, y'all.
Comparator
I
evidence.
can't. Go ahead. I'm sorry.
Comparator evidence shows similarly situated employees, white male and one white female, Ashley Dempsey, DAS HR Generalist 3, a defendant in this case, returned from FMLA leave without adverse changes. In fact, some were even promoted, such as Ashley Dempsey, who advanced from DAS HR Generalist 2 to do DAS HR Generalist 3 upon her return from FMLA leave in 2025. These facts support both interference and retaliation claims. Potenza versus City of New York. The independent Rule 26F report documents that defendant's reassignment occurred immediately upon plaintiff's return, while comparators returned without change. This comparator evidence is already preserved in the report and directly rebuts defendant's claim that no adverse action occurred. Defendant conduct relevant to FMLA and CT-FMLA claims. Defendants interfered with plaintiff's approved FMLA leave and retaliated by reassigning her duties immediately upon return. Their major conduct is summarized below, with all additional actions detailed throughout this opposition. Plaintiff's retaliatory 62% duty reduction stands in stark contrast to the treatment of similar situated employees. For white male employees who returned from FMLA leave in 2022, 2023, 2024, and 2025 were each restored to their full duties without reduction. Likewise, defendant Ashley Dempsey, a white female HR Generalist 3, returned from FMLA leave in 2024 and was restored to her full responsibilities. In addition, a 27-year-old white female secretary 2 hired in November 2023 was promoted in August 2025 to licensed application analyst in the boiler unit, while plaintiff, a state employee since 2001, was stripped of approximately 62% of her duties and denied advancement. This comparator evidence demonstrates disparate treatment, undermines defendants' claims, business justification, and supports plaintiff's FMLA retaliation and Title 7 ADEA discrimination claims. Plaintiff's rights under the Family and Medical Leave Act and Connecticut FMLA were interfered with and retaliated against. Plaintiff was approved for protective medical leave beginning October 2024. Plaintiff was approved for protective medical leave beginning October 2024, supported by multiple medical certificates documenting severe anxiety and depression caused by workplace retaliation. Human Resources confirmed plaintiff's eligibility, received her signed intent to return, and cleared her to resume work on November 19, 2024. However, upon return, plaintiff was not restored to her equivalent position as required by 29 U.S.C. Section 2614 and Connecticut General Statute 31 through 51. Instead, DAS issued a formal notification letter reducing plaintiff's duties by approximately 62%, reassigning her statutory codes amendment subcommittee responsibilities to the legal division and to a younger comparator employee. This material alteration of plaintiff's position immediately following protected leave constitutes unlawful interference and retaliation under the FMLA. The timing combined with comparator evidence showing that similar situated white males and females employees were restored to full duties after FMLA leave demonstrates discriminatory treatment and pretext. Plaintiff's retaliatory duty reduction stands in stark contrast to the treatment similar situated employees. For white male employees while who returned from FMLA leave in 2022, 2023, 2024 were each restored their full. Did I read this? Did I go
Yeah, it's
backwards?
repetitive. No,
Okay, hold
but we
on.
could skip all this. We already read
Okay,
it. We already
okay,
read it. You could jump to number 5.
okay. Evidence of retaliatory investigations and biased responses. A defendant's conduct relevant to retaliatory investigation, biased responses, and IIED. Defendants engage in retaliatory investigations, obstructive responses, and extreme conduct that support plaintiffs' claims of retaliation, discriminatory motives, and intentional infliction of emotional distress. Their major conduct is summarized below, with all additional actions detailed throughout the opposition. Defendants attempt to characterize the issuance of multiple letters of expectations and counseling memoranda as routine management. This argument is pretextual. The timing of these documents, issued immediately after plaintiffs engaged in protective activity by filing EEO-CHRO complaints and raising statutory objections, demonstrates retaliatory motive. Moreover, comparators such as Hart Saucy were reassigned or promoted without discipline, and Vasquez outside YouTube activity were tolerated without investigation. The selective enforcement against plaintiff, coupled with the omission of her evidence from HREEO reports, revealed that these performance documents were not neutral management tools, but instruments of retaliation designed to silence protective speech and strip plaintiff of her duties. In addition, plaintiff's contemporaneous emails with DAS EEO specialist Ashley Berg document aggressive retaliation and biased investigatory practices. Plaintiff reported that her evidence was omitted from the intake statement, that HR refused to record the interview despite her request, and that she was pressured to sign a flawed statement. Plaintiff also documented that defendant Z improperly allowed Secretary 2 Danielle Hart to direct plaintiff's work, undermining her authority and evidencing discriminatory duty reassignment. Burke's responses minimize plaintiff's concern and focus only on procedural timelines, failing to address the substance of plaintiff's retaliation claims. This exchange supports plaintiff's Title VII hostile environment and retaliation claims and her IIED claims by showing biased investigations, omission of evidence, and retaliatory manipulation of internal procedures or processes to disadvantage the plaintiff. On December 23rd, 2024, defendant Jordan Kubik issued an EEO investigation report that mischaracterized plaintiff's cultural commentary and protected speech as misconduct. This report was finalized just 1 month after plaintiff returned from FMLA leave, further reporting retaliation. In early 2025, defendants submitted their formal response to plaintiff CHRO complaint. That response repeatedly stated insufficient evidence to other to either confirm or deny.
All right. You could jump down to page 27 and go all the way to the bottom to the conclusion. Because the audience already knows this. It's repetitive at this point, but the
Okay.
audience already knows this. So where it says conclusion,
Okay, I see it. Conclusion. For the foregoing reasons, plaintiff especially requests that the court deny defendant's motion to dismiss in its entirety. In the alternative, plaintiff requests leave to amend to cure any deficiencies identified by the court. Plaintiff Independent Rule 26F report is part of a record and demonstrates both the factual basis of our claim and defendant's obstruction of discovery. The report documents adverse employment actions and comparator evidence, retaliatory investigation, and constitutional violations, all of which satisfy the pleading standards under Twombly and Iskabal. Plaintiff has already shown violations of clearly established rights supported by documentary proof and comparator evidence. Exhibits G through I, duty reassignment letter, 62% reduction and reclassification documents, and exhibits J through M, which is job description, organizational charts, and title records, showing inconsistencies for Z and Hobbs, further confirmed defendant's supervisory authority, discriminatory intent, and manipulation of title to obscure accountability. Accordingly, the court should deny dismissal and allow discovery to proceed so that the full scope of defendant's discriminatory and retaliatory conduct, including statutory violations under Title VII, ADA, ADEA, and FMLA, and constitutional violations of the First Amendment, may be adjudicated on the merits. Note regarding
and that's it.
exhibit.
You can stop there.
Okay.
You
Okay.
can stop there because this was a note because I was having issues with the CMECF system to upload the 300 exhibits.
Mm.
And it took me 2 or 3 days to do that shit, but I got them bitches up there.
Wow.
It took you know what I had to do? It was because you couldn't have any links in it. So what I needed to do was change the document to black and white, which wouldn't trigger the links. And they uploaded professionally. They uploaded fine. So I mean, we have the after I uploaded that, they did some kind of stupid reply. They couldn't even shake it because those 300 exhibits killed it. They're on the docket. 300 exhibits dating back from 2016
You said I
all
don't have
the way.
nothing. I'm gonna show you what I got, and you uploaded 300 exhibits. That's crazy.
Yeah, they're all on the docket.
And
You
another
know,
thing which
anything
shows
outside. Hmm.
another thing that shows kind of guilt or guilty mind is that after you said you filed you filed a complaint, they reassigned that girl, that Secretary
Yeah,
of State. Yeah, so or Secretary, what is she? Secretary number
she was
2.
a sec too, and one of our colleagues passed away, and so they trained her for that. But that's how it goes. That's what it is. But I just strongly encourage people to fight. I I I'm not intimidated by people. I don't care who you are, and I'm gonna fight. And no lawyer is gonna fight for me like this. It's just not gonna happen for anybody. Some things you have to fight for yourself. So why would I even pay a lawyer when I'm gonna do a better job than him representing me? And like I always said, and I don't care if people don't like it, I'm not Dred Scott. See, we're still viewed, even to this day, we're still viewed as, and that's the end of the case for now. I come back and do the Sur Reply some other time. That's a ball buster, the Sur Reply. I'm not afraid, and that's, these are the things what happen to you when you stand up and ask, why certain things are that way in your unit. Why is everybody going up the scale except me? How come I can perform the job but can't have the title that goes with it? So the minute you ask that, oh, it's more like, and in this is my thought in my head, nigger, you can do the work, or uh, shut up. That don't set well with me, and it's even more devastating when other people are put in there to um shut you down, diminish you. Right now they hired um 3 people to do my job. 3 people to do the job that I've been doing that takes 3 people to do. But the whole time when I was doing it from 2017, 16, all the way up to 2024, I was doing a 3-person job. But I was comfortable with it. I was happy. I was always busy. I didn't move from my seat. I was always there because I like law and I like watching um deliberations. I like see it's more like watching a bench trial. So I never had to turn my camera on, but I would watch, the committee members hear cases and hearing both sides, and then they deliberate. Was the perfect job. But then you have people that come in 2022 and 2023 who are evil, and these are the things that happen to you. But I'm not afraid to fight. I've never have been. And I am not a person that takes intimidation at all. I don't fear intimidation. I don't fear bullying because I've never been a bully and I've never been scared of bullies. So somebody with a high extreme just doesn't scare me. To me, you're just a person standing in front of me. And I'm not going to stop fighting. You have to keep fighting. You can't give up. And things are done deliberately to diminish your health, but I'm fine. I'm fine. There's people in there in their 30s that look like they in their fucking 70s. I'm fine. Yeah, it hurt a little bit, but that was depression. People come in and out of depression. But this is what happens. And you should get an attorney. No, I'm not fucking getting one. I don't need one. The hardest part of this federal job is already done. The rest is easy. Discovery. All you gotta do is present proof. And then jury trial. It's fun picking your own jury. And I'm not gonna give up. And I hope everybody that's watching, it also probably helped because a lot of attorneys watch my channel. And I help a lot of attorneys. Even now, they call, and a lot of them struggle with things. This is why I said it makes no sense for me to get an attorney. But not every pro se litigant is in my position either. You know what I mean? A lot of pro se litigants have not, had experience in law, but they try and do the best that they can. But they get kicked out for technicalities and things of that nature. It's tough for people in our community to defend themselves because even if a judge doesn't dismiss a case, or if it does, do they know how to appeal to the Second Circuit? A lot of people in our community can't do this. That's why a lot of them suffer because number one, they can't do this kind of work. Number two, they don't have enough money to pay an attorney to represent them. And if they get an attorney, they're going to get lowballed and ripped off. So there's a lot of circumstances that stop a lot of people from fighting. But I've always been a fighter. I guess it's just in my blood. And I don't care. I don't. I don't care. I stand on my constitutional rights, which everybody should. I don't give a fuck what your race is. If you're a United States citizen and your constitutional violations are being violated, you fight. You stand on your rights. Don't let them go. So I help all people. And that's why I have my lecturing channel for the purpose to help United States citizens. Because if we all don't stand together and stand on the Constitution, then we fail. So I'm filing this in hopes to for this to be a precedent decision for somebody else. That's the way you can help the public. And if the biggest blessing would be to have this decision be a precedent so that it could guide others on what they need to do to prove their cases. And they think all through the years, no one ever thinks of saving every document makes sense. Every email makes sense. Don't delete them. It tells a story. This is why so many people in offices that have business jobs in office and they communicate, never delete emails. You print them and save them on a flash drive, and you consolidate them into one document on flash drives. I have over 40 flash drives, but that's all information held. Most people don't hold that amount of information. I have stuff from 2016 all the way up to 2024. And I had to say, because if I lose it, then I wouldn't have anything to back me up. And what happens is when you save documented information from that many years and you consolidate it in one document and you analyze it, it tells a whole story about your life at work. And you wouldn't even believe what comes out of it after it's analyzed. And today it's even easier to analyze documents in tools like Copilot. You can analyze it. I think Copilot only takes up to like 13 pages. So you can analyze a whole 10-year story and see what was done to you and how it was done. It tells a complete story of what a state agency did in your career. And that's something that you give to the judge and the defendants. You don't remember this. And then when the defendant sees something, their biggest attitude, well, fuck, I wasn't here in 2017. I didn't come here until 8 years later. The fuck? So how did she keep it up? My file. Your personnel file tells a story. Every email you send out in communicating with your colleagues, your boss, those are important emails. You don't delete them. You start every day, you save them. At the end of the day, your last task should be printing out all the communication you have for the day. And all you got to do is look in your sent basket and just highlight everything, print it out onto a drive, not on paper. You save paper. When you get flash drives, you save printing money because you download. You look in your sent boxes for the day. Every day you go to work, and you know what? You need to put it as a reminder on your calendar as a daily thing to remind you to do. It's the last thing you do before you walk out of work. I have like 40 of these, and that covers my entire career in the state, in this particular agency. And you look in before you leave, your calendar is going to say, hey, Bethy, print those emails, and you print it and you save it. And then because everything is systemic, you're ready for war because you have everything that they claim that they didn't say or do right in the email. And most people don't think, oh, it's too late. Get IT to wipe everything out. But when you're the spook who sits by the door, you learn this many, many moons. Some of this, you guys weren't even born when I was saving stuff. And it helps you. The best part of a employment discrimination case or whatever, Title VII and First Amendment rights, your biggest weapon is everything you've saved in your career. Even emails where you're complimented from the public, where you're complimented from your boss. The same guy that's saying you're all this now is the same guy, and it's funny, that trained you. So you obviously know I know my job because you trained me to do it, because this is a job you used to do before I did it. So how all of a sudden I'm not doing something's not right. I come back and now I don't have the job that you trained me. What happened here? Oh, because that nigger's performing statutory functions and she's terribly working out of her class because she was assigned to the codes and standards committee on her date of hire. That's why they hired me, because of my legal background, and I would be able to manage the committee's functions. All the committee members had to do was show up because I handled everything. I managed it, the hearings, everything. So to be this, you know, but an importance. I don't care if you think it was just one email that said, "Hi, how you doing?" You save it because it shows deliberate, intentional. You save everything on the drive. It tells a whole story. And then those are the stories that you hand to the judge. It's accurate. It's all on a disc. You can't lie. You said, "I'm not performing statutory functions." Okay, here it is. DAS agrees that I'm performing statutory functions, but I'm a little niggy. You can do the job, but you're not getting the title. So you fight. You fight and you don't give up. This is your ammunition. Having 40 of these is your ammunition. My entire file from when I first started with the state of Connecticut in 2001. Some people weren't even born at being YouTube. It's all on these drives. All my HR files are on this drive. I don't throw away nothing. Because in your lifetime, it's going to be needed. And after your health goes down and get triggers at a point, that's when you need it. You have your ammunition. You don't need weapons of destruction and all this shit. All you need is a flash drive. And the ultimate decision is made by the judge. Judge has the final say. I don't know what the judge's ruling is going to be. I don't know. I can only analyze and base it on past cases. But from the start of it, everybody looks like, it doesn't look like anybody's going anywhere. None of the defendants will be dismissed because they're all liable. And at this stage, all you could do, all you have to, the judge has to believe everything that I say is true and plausible. So the best part of the case is discovery, because you have all the shit that they can't deny. So that's why it's so important to save everything. The hell with printing it out. We're not in the 1980s no more, where you need to print it out on paper and have all these thick folders. All you need is to go to CVS and buy a bunch of these, or Walmart, and buy a bunch of them and just store every day.
Are you
Every
saying that?
contradiction is in there.
So you're saying that you have your, like your praise reports from way like 2001, 2002, like you've been
Mhm.
saving these?
Mhm.
Wow.
I got everything. Yeah.
Wow.
But see, prior to working for the state, I was working in another company for 10 years. And then and what happened, the unnamed law firm that I was working for, instead of full time, I went to part time. It was my choice because I really wanted to get a state job. So I began working for them part time, right? And working for the state full time because I was so excited. So I took the state full time job, and that private sector law firm job became part time. I was full time there, and I was always in the courthouse with my boss, and traveling, doing depositions, and taking all that stuff. But I became full time in the state. And one of the things that I learned that I could never do, some jobs are very hard to do because you got to sleep at night. I'm human. And I would never work for like an attorney general's office because I know I have to defend the state. And if somebody's doing what they did to me, I couldn't fight them. I wouldn't want to harm them more. So those kind of jobs, I was reluctant to take those kind of legal jobs, wanting to work. Not to say that the attorney general is mean, but I can't do a job where I defend a state that does harms to thousands. I can't do it. And then live with myself at night, knowing somebody is suffering what I'm suffering, and work in an office like that to get them on a technicality and all this other stuff. I can't do it. I can't. So I'm more for the people. You have some people that's for the state, and you got some people that's for the people, for the citizens. I'm for the citizens because I wouldn't want what's done to me to anybody. I wouldn't want anyone to suffer what I'm suffering. Now we have employees that are going through the same thing as me in the state, but it's up to them to fight their own battles. I'm not an attorney. I can't go to them and say, hey, look, you're working statutory functions. You're being underpaid. I can't do nothing like that. And I wouldn't do it. I won't. It's not my role. My only concern is myself. I can only represent myself. I'm not an attorney. So I use the tools that I've gained in life to fight because that's what they're there for. I mean, normally people use those tools to work for an attorney, to assist the attorney, but you also have the tool to fight for yourself. And why bother even getting an attorney when they're not gonna fight like me? Because I'm gonna fight like a she devil. I'm not gonna stop. I'm not gonna give up. And then they do try to do psychological things like, "Whoa, this didn't really happen." Yes, it did. But in order to keep your job, you remain quiet. You say, "Okay, I'll do it. No problem." But I'm not gonna pull my case. Don't ever pull your case. And right now, where we're at now on the docket is the judge has not made her ruling on the motion to dismiss. Obviously, it's not going to be dismissed because it's too plausible. That's my thought, though, but also a lot of other people's thought too. Um, it's been sitting 8 months. 8 months. They've been reviewing it for 8 months. That's a very long time to make a motion to dismiss ruling. I don't think it's going to be what I think it will be, granted in part and denied in part. But all the major federal um, constitutional claims, those will go straight to discovery because they're too plausible. But we'll see what her ruling will be. I don't know what it's going to be, but it's been 8 months now. Most motion to dismiss rulings are made anywhere between, if the judge is going to kick it out, they usually dismiss it within the first 45 days. If it's complex, if it's a complex case and have multiple defendants, like I have 9 defendants, it takes a little longer. But even those only take like up to 120 days, maybe 3 or 4 months. But this case is so complex. It's like catastrophic. It's so complex that it's been 8 months and no decision had been made. Now, don't forget, um, district judges' dockets are heavy, so they don't only do civil rights case ruling. They also do uh, criminal. They do that, so their dockets are full. I could never be a federal judge. That's a lot of work, and it's a lot of mental thinking. I mean, they have staff that help them, clerks that help them in their chambers, the ones you don't ever see. But it's still a lot of work on a justice's head. This is why I say, like, federal judges are judges that uh you don't want to get on their bad side in court, or because they come out with serious scrutiny. They don't Federal judges are different from state judges. They don't play. They're lifetime appointments and they don't fucking play. They have zero tolerance. They don't have seriously. But you go ahead and talk for him for a minute. I gotta go get my crabs. I'll be right back. Talk to him, instance. I'll be right back.
Well, I do think that this was like really interesting, really informative, and it kind of just educates all of us to show how it can be done. And, if you're not good at writing these pleadings or something like that, you can always get it's paralegals all over the place that can help you write it up. So, because some of these attorneys won't even take the case, or it seems like they'll purposely sabotage the case. And so a lot of our claims aren't going heard. But then you'll see somebody else who will have like way less, and then they're getting all of these lawsuits adjudicated and actually supersized settlements, and they're going through less than what we're going through. So in order to bypass the gatekeepers, this is a great way to just put it in yourself. You feel like you have a claim, put it in yourself. So, and I also think that Sister Bethy, I'm not a lawyer, but it just seems like she has like a great claim and she articulated it well. I understood it. Taking somebody who is fairly new and giving her your responsibilities is quite evident that something was going on. So.
Oh, I'm back. Sorry. I said crabs. I meant stuffed clams. I love stuffed clams. That's my lunch. Yes.
Nice.
Stuffed clam. That's right. I love stuffed clams. Y'all gotta excuse me because I didn't eat and I'm getting a little hungry. I lost 30 pounds too. I'm gonna still keep going because I walk every day now. Do a lot of walking. Dropped 30. See it? I don't know if you could see it, but my daughter's like, "Mom, you going back to when you was younger?" I said, "I sure am. I gotta get this weight off of me." But I did good. Yeah, that's why I'm smaller now. So, and I had to go and buy new bras because they're too big. The round part, I had to get new ones because
You just did that by walking?
Yeah, just walk. Walk. I walk a lot.
Nice.
Yeah. That's because I only gained it because it's depression. That was depression weight. And I put on that weight when after Ray died, my husband, after he died, um I gained and ate because some people won't eat when they go in depression. Then you have those that eat. I was an eater. I would eat in depression. But now I just done dropped it. Dropped all that weight. It ain't healthy anyway. I don't have no diabetes and all that stuff. I don't want it either. So, Hey, Smoke, I saw you. But now, is it difficult reporting to work every day? No, because when you're mistreated for so many years and overlooked for so many years, you get used to it. Does my lawsuit affect me at the same time it's still working? No, not at all, because it still doesn't amount up to and compared to what was done to me. But I'm strong. Some people give up, not me. I'm not. I'm not even built like that. The more you try to destroy me, the stronger I get. That's how my body works and my mind works. So I highly recommend people all over the United States. Hey, Chief, stand on your constitutional rights. This is why I teach and lecture about law on my YouTube channel so people can learn. A lot of attorneys learn, and a lot of them cash at me because they struggle with some things. Attorneys are specialized in the areas of law that they specialize in. Like real estate attorney is not the best attorney to represent for employment discrimination. You know what I mean?
I know what you
But you have
mean.
to stand and
I'm
fight.
like thoroughly versed in medical legal law. But if you ask me
See,
about, something else, I mean, I understand legal terms, but, you know,
my
peace, Chief
whole
Holiday,
life, hey Chief, my whole life has always been employment law
employment.
for the most part and criminal, but to a certain extent, I was the one that went in there, in the courthouse with my boss, 250 to get you continuous. For my boss, when he was a criminal law, and he was for the defendants, bad boys. 250 will get you in contingency all day. 250 will get you in contingency. And then, drug dealers have $250. Oh, bet. A continuance. It's just so horrible when you really think about what it is for. It's buying time for Pookie and Ray Ray. It's just horrible. So I never turned to criminal law. I stuck with the employment law. A lot of people are harming and hurt. But anybody, watching the channel, they can literally see what's being done to them just by hearing the story. And you learn the story by reading case laws and court rulings. And some for the people that can't have reading, comprehension issues, they listen to the live and that helps them. It helps them because you have your visual learners and you have your hand-on learners. You have your audio learners. So I like to do both on my channel. Give them the audio and the visual, which is with the slides. And to me, that's the best way you can help United States citizens. But don't fight your constitutional rights. That's what federal courts are there for, to protect the individuals, United States citizen, protect their rights. A lot of people don't know that. So they run to state court. They go to the same place where the harm is done. I don't like state courts at all, ever. I don't. And people just don't care. But me, I just think of things as karma. What's done to you, what somebody does to you comes back on them tenfold. That's it. That's all you could do. I'm not a violent person. You just let Like we say, our coping mechanism, let go and let God. Bottom line. That's all you do. And you keep fighting every day. Hmm. So, Isness, you have been a blessing to me today. You just don't know because I did not want to read and lose my voice. You guys, Isness helped me out so much today just for reading. And this, like I said, this is public information. It is what it is. I'm not going to let people bully me off of my channel from helping citizens. Anything I read is already in the court docket, and I'm allowed to read my own personal case online live because it's public information. It's already there.
And I feel a
I'm
certain way
media.
about whoever it is that tried to get you taken off of your job. I feel a certain way about that person who's listening, who has listened to you. So I feel a certain way. I'm not going to say it because
That's what they do until it's done back to them.
that's right.
That's the way I look at it. What you're doing to me is going to be done back to you.
That's right.
I let people dig their own pits. Right now, the only person who could rule on this case is our assigned judge. And we have to wait for a ruling. I don't know what it's going to be. I have no clue. The only thing I could do is analyze and compare it to other cases. And that because that's all I have as far as what the outcome may be or may look like. But nobody has the final decision, but that district judge. For real.
I think
Nobody
you will
knows what the
prevail.
judge is
Yeah.
going to rule. Hmm?
Right. Well, I
I'm
think
sorry?
you'll prevail. I think you'll prevail. It was pretty compelling to me. So, like you said, we don't know what the judge is going to do. It has not the dismissal has not been granted. So, you know, we rooting for you, Sister
The
Bethy.
motion to dismiss was yeah. The motion to
Yeah,
dismiss was very weak.
right.
It really was. It was boilerplate.
Yeah.
But the thing that helps me is all the exhibits. That's why I said I can't wait to discovery. And those 300 exhibits ain't shit to what I have. Those was just enough to put up there to substantiate everything I was saying. But there's more. But I gotta wait. And it's still ongoing. I can't speak about anything outside of what's on that docket. So I won't. But just know that we do have 2026. We're in 2026 now, 8 months into 2026. So, that's all discovery stuff. Um, I'm not worried. I'm not worried. I'm healthy. I had the proper treatment, to get me through it, what I was going through. And I'm okay. That's why I'm back alive. I wouldn't I wouldn't wish this on my worst enemy. I could tell you that.
And I do appreciate the kind compliments. I do appreciate it.
Of
You got it,
course.
Sister Bethy. We gonna come back
Yeah, I'm
through with
trying.
the
We've been
update with a
on.
positive update. Yeah.
Yeah, I'll let you know. I keep everybody posted. So you could always have this video to watch and listen to what I went through so that you understand the same thing for yourself. But I'm telling you, and I can't begin to tell you this, save every email on a disk drive. Every day, you got to save. You got to be consistent. But we've been on for 4.5 hours, girl. And I'm going to get off from here and rest for the rest of the day because I do have to go to work tomorrow. Listeners and everybody in the chat, I love you guys for coming out. You've been awesome. Business. You're always awesome.
Oh, thank you. Peace,
And I'm
Sister
gonna
Beth.
end it. Hang on in the back for a minute while I give
Okay.
everybody some music.
Okay.
I love you guys. Have a wonderful rest of the day.
Peace,
Get some
y'all.
rest.